not considered a victim of the manufacturer defendant's fraud
Didn't
today.
you say you weren't going to challenge that? Oh, the agrees part.
Correct. It's all about the agree.
Yeah, can't you just
That
say-
language is fine, but the heading of the slide should be, on May 15th, 2018, the Office of the Attorney General alleged.
Your Honor, if we're going to now talk about allegations, we're right back to a complaint, and we should be able to bring in the complaint. The whole purpose of getting away from allegation is that we're not allowed to talk about a complaint. At this point, we're now just talking about a statement. We're entitled to characterize that how we'd like. They can argue it. They can talk about how, no, she doesn't agree. They can try to explain that to the jury. Mr. Webster this morning put up all kinds of slides characterizing Walgreens' statements, characterizing what Walgreens said back at the time, what we think today. We're entitled to the same thing, especially if we're now getting away entirely from where we should be, and that is talking about the complaint that she filed. So if they want to argue that to the jury later, they can. But I think our slide's entirely appropriate. It says the Florida Attorney General agrees, and then we just took the language, we took out any reference to manufacturer defendants, to distributor defendants, we just said these companies.
They can't characterize it any way they want. They can't say that the Office of the Attorney General joked. It was either, it will allow stated, but it was either alleged or stated.
It can be alleged or stated, but I don't think you can say there's an agreement that that's the truth. You're allowed to use statements against somebody, but you can't say that they agree with that now.
Understood, Your Honor. We'll need just a few minutes then to adjust the slides.
That's fine.
And it has to be the Office of the Attorney General because the current Attorney General did not sign that complaint and did not agree with it or allege it or anything like that.
Your Honor,
So
Mr.
it has to be
Webster
the
is
Office
now
of-
writing
May I
my...
finish, please? It has to be the Office of the Attorney General. That is technically accurate. And it should also specify the date because this is not a current statement by the Office of the Attorney General. It was a statement on May 15, 2018.
Your Honor, if I knew the ground rules were that when we...
It's fine, you don't have to argue.
Thank you.
I'm not getting that technical on it. You can make whatever arguments you want, whatever arguments you want, final arguments, but he can say these statements for me.
Thank you, Your Honor. I'll go ahead and change those slides to say the Attorney General stated.
Okay.
Pleasant seeing you.
All right, thank you. You may be seated. All right. Welcome back, ladies and gentlemen. You should have your notes there. And I'm going to turn to you. And I hope you had a nice lunch. You're ready to proceed. You may proceed.
Thank you, Your Honor. Ladies and gentlemen, good afternoon. My name is Steve Derringer, and I represent Walgreens. And there are three things that I'd like to say to you right up front. The first thing is this. I am deeply honored to be standing here in front of you today, and I am incredibly grateful for your time and your attention and the time and attention you are going to be giving this case over the course of the next few weeks. And I and my team, we promise to do our very best not to waste your time or your attention. The second thing that I'd like to say to you right up front is that the opioid crisis here in Florida, it's real. It has ravaged communities. It has shattered the lives of individuals and of families. And we at Walgreens take it very seriously. You're going to hear about that over the course of the next few weeks. And the third thing that I'd like to say to you right up front is that the opioid crisis in Florida, it's not new. You will learn that the state of Florida has known about that opioid crisis for a long time. During the course of this trial, I am going to show you what the state of Florida had to say about the opioid crisis all the way back in the early 2000s. I'm going to show you what the state of Florida did do and what it did not do about that opioid crisis. And I'm going to show you what the Attorney General and her office, what they have said about who is to blame for the opioid crisis. And one of the things that I'm going to ask you to focus on during our time together over the course of the next few weeks is this. I'd like you to pay close attention to the difference between what the Attorney General's lawyers say to you here in this courtroom versus what the Attorney General's office itself and the people who've worked in her office themselves have said before, outside of this courtroom, in real life, in the real world, when they were discussing the opioid crisis and who they said was responsible for it. Now, I am going to get to all of that, I promise. But the first thing I'd like to do is to introduce you to the Walgreens team here today. I am very pleased to be working with my partners and my colleagues who will be trying the case with me over the next few weeks. You've already met Casper Stoffelmeyer. You may remember you had a little interaction with him. It was a week ago today.
Nice to see you all here.
Casper and I are joined by our colleagues, Wesley Morissette, Jordan Golds, Dan Taylor, and Alex Schultz. And we're proud to represent Walgreens here in this courtroom today and in this trial. But the most important person that I'd like to introduce to you here in the courtroom today is Nick Vasilakos. Nick, stand up for a second, say hi to the jury. Nick graduated from pharmacy school back in 1985. He went to school for 5 years up in Pittsburgh, Pennsylvania, Duquesne University. He became a licensed pharmacist in 1986 and moved down here to Florida to get away from the cold in the Northeast because, well, he had had enough of it, enough of the cold, enough of the winters. He started working at Walgreens here in Florida all the way back in 1991, and you're going to learn that he's worked in the Newport Richey area ever since. He actually lives down the street from here. And up on the screen, I've put a picture of the store where he works, 9220 Little Road. Nick and his wife have raised two wonderful daughters here in the community. The older one is starting graduate school this coming summer. The younger one is finishing up her second year of college. Now, Nick's not going to be able to be with us every day here in court. In fact, most days he won't be with us. He will talk to you a little bit later on. He's going to testify in this case. But he's not going to be able to be here every day. Don't hold it against him. He's going to be over there working behind the pharmacy counter at the Walgreens over on Little Road. Now, I'd also like to introduce you right up front to a little bit about what Walgreens does do and what Walgreens doesn't do in this entire process of how opioids get made and marketed and distributed and prescribed and then dispensed. And you're going to hear during the course of this trial about a few different entities, right? One is what we call the manufacturers or the marketers. And these are the folks who actually make and promote the opioids that you're going to be hearing about. One thing I want to be real clear about, Walgreens does not do that, has never done that. Then you're going to hear about another group of companies called distributors. And these are the companies that order medicines from the people who make them, and they store them in these central warehouses. And then what they do is they take orders from other places, could be pharmacies, could be hospitals. You're going to hear a little bit later on about something else called pill mills. Some of them took orders from pill mills. And they send those orders over to the pharmacies, the hospitals, or the pill mills. Now, Walgreens used to do that. Walgreens was a distributor at one point in time. But the important thing to understand about Walgreens is we were what's called a self-distributor. The only people we ever distributed these medicines to were our own pharmacies. Our own pharmacies. And one of the things that you're going to learn in this trial is that distributors, one thing they should be sure to do, it's a good idea, they should know their customers. They should know the folks to whom they're sending the medications. For Walgreens, you're going to learn that was pretty easy because our customers were ourselves. We were shipping this to our own pharmacies and only ever to our own pharmacies. And then another group you're going to be hearing about in this trial are doctors. I've kind of put this little image up here on the screen of a prescription pad, a doctor kind of handing that out. Doctors. Doctors are the ones you'll learn, they're the ones who prescribe medication. Remember I talked about manufacturers? Walgreens never did that. Talked about distributors. We did do that at some point in time, but only sent stuff to our own pharmacies. Doctors prescribe. We've never done that. Walgreens does not prescribe medication. We are not the doctors. We're going to learn about the role of the doctors, but one thing I want to stop right now with is this, and you know, this is a blank prescription form that you can see. Now, obviously, in this case, we're going to be talking about a particular type of prescription, a prescription for an opioid medication. And this morning, Mr. Webster talked to you a bit about opioids, and he was making these statements, these parallels between opioids and heroin. Opioids and heroin. One thing the evidence is going to show is that there's not a single prescription that Walgreens filled for heroin. Not one. And the other thing you're going to learn in this trial is that those opioids that Mr. Webster was talking about in terms of, you know, wreaking all kinds of havoc and having these terrible, terrible consequences, they are pain medicines approved for use by the United States Food and Drug Administration. You're going to learn about that. They have approved uses for real and debilitating pain. Now, that's not to say you shouldn't be real careful with them, but the idea that every opioid that's out there, every prescription that's filled for an opioid, you got to watch out because that's a bad medicine. That's just not true. You're going to learn about that. You're going to hear about the very beneficial uses that opioids, properly prescribed, properly dispensed, and properly used, you're going to learn about the benefits they have. And that brings me to another piece of this that I just want to kind of bring out. I didn't put a slide in on it. But we talked about doctors here, and we're going to talk a lot about pharmacists. Another piece here that you're going to learn about is there's another group that plays into this whole story. And that's the patient. That's the patient. You're going to hear about how doctors and pharmacists work together with patients to make sure that people get the treatment they need. You're going to hear about a responsibility that the patient also has to him or herself to make sure that they use the medicine properly. All right. Now, those are the doctors. They prescribe the medicine. They give that prescription to a patient. Patient takes it to a pharmacy. We're not the manufacturer. We did some distribution. Stop doing that. Only distributed to our own pharmacies. We're not the doctor. You know what we are? We're the pharmacy. We're the pharmacy. And that's where pharmacists take in the prescription, review them, and make a decision about whether or not to dispense the medication. So Nick works right there at 9220 Little Road. Now maybe you visited there, maybe you haven't, I don't know. But I'm pretty confident that you've probably visited a pharmacy once or twice in your life to fill a prescription. And so, even though you don't know Nick, you probably do know your own pharmacist, or you've had some interaction with your own pharmacist. So you're familiar with the fact that your pharmacist works in the community where he or she lives, just like Nick. Nick works in Newport Richey, he lives in Newport Richey. And just like Nick, your pharmacist probably went to pharmacy school. They went to pharmacy school for 4 to 6 years. And when they were at school, your pharmacist, like Nick, like every licensed pharmacist, like every Walgreens pharmacist, they learned about biology and chemistry. They learned about drug therapy. They learned about all kinds of details on what you do to dispense medication, what things you look out for. They look for and they learn about those things that Mr. Webster talked to you about. I'm going to get back to them, I promise. Red flags. They learn about those. And they learn about how to counsel their patients. Patients might say, hey, I have a question about how I take this medication. Nick and other pharmacists, when they're in school, they learn about that. And at the end of that, they get certified, they get their license, they get their degree as a pharmacist. But a pharmacist, you will learn, is not a doctor. A pharmacist is not a doctor. There's some important differences. A pharmacist went to medical school. I'm sorry, a medical doctor went to medical school. A pharmacist didn't, they went to pharmacy school. Medical doctor got clinical training on how to treat patients, how to interact with, how to diagnose patients. They did internships and residencies and fellowships. If any of you know doctors, you know they go to school for a real long time. Some of them, it seems like forever. It's because they go through all these different experiences to learn more about how to examine and diagnose and treat patients. Doctors are licensed by the Florida Board of Medicine, and they're licensed to be able to practice medicine in this state and to prescribe medicine in this state. Pharmacists can't do either one of those things. Doctor holds something from the Drug Enforcement Administration, holds a registration to prescribe controlled substances. Now, controlled substances are these special classes of drugs that are so specialized and important and could have, they could have some consequences you really want to be looking out for. You need to be specifically registered by the Drug Enforcement Administration, if you're a doctor, to be able to prescribe those. So doctors can qualify to do that. Pharmacists, of course, cannot. Doctors have access to a patient's medical history. Pharmacists don't. Doctor actually examines the patient. It's not something the pharmacist does. And after they examine the patient, that doctor can order tests, they can order blood work or x-rays or MRIs to try to figure out what's going on. Pharmacist doesn't do any of that. And after they've examined the patient and ordered some tests, they actually do the work of diagnosing the patient, figuring out what's wrong. And that's why doctors in our medical system, doctors are the ones who prescribe the medication. Pharmacists are the ones who dispense the medication. Our Our medical system is set up so the doctors who went to medical school, who know their patients' medical histories, who've examined their patients, who've diagnosed their patients, they're the ones who determine what medicine is best for their patients. Now, pharmacists have an important role. They're there to be sure that that medicine is properly counted out, is in the right dose. They're there to make sure that that medicine doesn't interact in some kind of dangerous way with another medicine that the patient may be taking. And that pharmacist is there to answer questions the patient may have about how to take the medication. But the pharmacist is not there to second guess the doctor or to choose a different treatment that the pharmacist thinks might be better. Now, this is not to say that pharmacists don't have a really important job. They do. Nick does. They go to school for many years. They've got to qualify for and maintain their pharmacist license. They can't practice pharmacy in the state of Florida without a license. And if that license is revoked, if they don't meet those standards, they can't work as a pharmacist. They can't work in the field that they were trained to work in. They can't make a living as a pharmacist if they don't have that license. And you know what? Pharmacists, they make a good living. They earn a six-figure salary. So you're going to hear from Nick and others that our pharmacists act diligently and conscientiously to make sure that they follow the standards, the rules, the regulations, the laws set by the state of Florida. Now, I told you that our pharmacists work to ensure that their patients receive the medications that they need, that they are prescribed by their doctors. But our pharmacists also work hard to ensure that they are not filling for patients who don't have a medical need, or for patients who may be seeking that medication for reasons that aren't entirely on the up and up. You're going to hear a lot about this balance. You're going to hear that our pharmacists are actually trained throughout pharmacy school about how to best balance their job of properly dispensing medications to those who need them, and at the same time, not dispensing medications if they're unable to satisfy themselves that the medicine is for a legitimate purpose. And you're going to hear that these are judgment calls that our pharmacists make each and every day behind the pharmacy counter. Now, our pharmacists, they bring that training to Walgreens, and we train them as well. You will see that. We train them as well. And we tell them that this job that they have, what we call good faith dispensing medicines in good faith, striking that balance. We tell them that at Walgreens, that is not just a good idea, that's not just a goal, that's company policy. That's our policy. You're going to hear a lot in this trial about policies. And so I want to take just a moment to preview for you a little bit about our good faith dispensing policy. What does that mean? And let's just go back. It's a long time, right? I mean, maybe not, doesn't seem like it, but just about 25 years ago. 25 years ago, late 1990s, I'm showing you a document you'll see as well in this case. It's our good faith dispensing policy, our good faith practices back in August of 1998. And I think you heard this morning Mr. Webster say we didn't have a policy until 2012, something like that. This is 1998, here's our policy, and you'll hear that our folks are proud of it. And I want to just tell you a little bit about what it says. Right up front, our pharmacists, folks like Nick, are told that it is company policy that they must use the elements of good faith dispensing in conjunction with state and federal controlled, it says in conjunction with state and federal controlled substances. That was a typo. It was corrected later. It meant in conjunction with state and federal controlled substance laws. They gotta follow those laws and our policy when filling all prescriptions. The pharmacist must determine if a prescription for a controlled substance is dispensed for a legitimate medical purpose. Remember this morning, I think Mr. Webster said something about we were selling opioids like Tylenol, and our executives never told pharmacists to be careful about how they dispense. This is a policy specifically geared towards controlled substances. Our pharmacists always knew that when you're dealing with controlled substances, you're not dealing just with an over-the-counter Tylenol medication. This is the policy. This one's from 1998. Talks about company policy for dealing with controlled substances. So that was the first part of it. And then we had a section called elements. The elements of good faith dispensing that should alert a pharmacist to questionable circumstances are. And then we have these 7 bullet points, a few sub-bullet points there. You'll hear later that this is what we refer to sometimes as Walgreens red flags. Things that our pharmacists, we told our pharmacists, if you get a prescription and there's something that hits on one of these, you should be alerted. And we even told the pharmacists way back in 1998 what to do if they saw a prescription with this red flag, with this kind of circumstance. If a pharmacist becomes aware of circumstances, including one or more of the elements of good faith dispensing, one or more of these things, the pharmacist should not dispense the drug. The pharmacist should not dispense the drug. That was company policy. We told our pharmacists that you must exercise professional judgment regarding the patient's continued need for controlled substances. You must contact the prescriber, contact that doctor when all the elements of good faith dispensing cannot be met. You will learn, ladies and gentlemen, that this has been company policy for all the time we're talking about in this case. And that policy, you'll hear, if you just want to hear it in like one sentence, if you cannot validate that the prescription in front of you is for a legitimate medical purpose, if there's a red flag you cannot resolve, don't dispense. Don't dispense. All right. I want to move to a question that may be on your minds after you heard Mr. Webster's presentation this morning. He talked about millions and millions, I think he even used the word billions, of pills. So you might wonder, why are there so many pills? Why are there so many pills? Well, on one level, the answer is pretty straightforward. There are so many pills because doctors have written a lot of prescriptions for pain medicine. But why is that? What you're going to hear about in this case, I even think Mr. Webster previewed it for you this morning, is that in the 1980s and 1990s, there was a change that happened. There was a change in how doctors and nurses started thinking about how to respond with patients who were in pain. Now, it used to be that if you had chronic pain, just kind of that day-to-day backache, lower back pain, neck pain, whatever it might be, just never went away. That's chronic pain. It used to be that if you had chronic pain, there wasn't all that much to be done about it. But that perspective, you will learn, started to change among doctors and nurses. And you're going to hear from plaintiffs' own witnesses that from the early 1980s up through the 1990s, there was this increasing recognition that people who had chronic pain, they should get treatment. They shouldn't have to just live with their pain. There was a recognition that if someone was experiencing that kind of pain, it shouldn't be ignored. It should be treated just like we would treat someone who showed up at the hospital or the doctor's office with high blood pressure or an elevated heart rate. In other words, doctors and nurses started to understand that just like your temperature and your heart rate and your blood pressure and your breathing are vital signs you get checked every time you go to the doctor, pain was something that should be checked and monitored as well. And you're going to learn that this became referred to as treating pain as the 5th vital sign. And that meant that you should treat pain like you would any other vital sign. You should assess it and you should address it. You should address it by suggesting and offering treatment so that the patient's pain is managed. Now you're going to learn that in the early 2000s, even organizations that set standards for accrediting healthcare facilities, hospitals, they built into those standards the notion that, look, if you want our stamp of approval, we want to see your plan for how you're going to address your patient's pain. That was a big deal. You're going to hear that that was a big deal from the plaintiff's own witness. And I'm going to explain, the evidence is going to show what the plaintiff here, the Office of the Attorney General, what they say caused that shift in perspective. But there really is going to be no disagreement that in the by the 1990s, the standard of care among doctors and nurses about how to treat pain, it changed. And it recognized that pain should be treated. Now, by this time, we actually, the medical community, had had years of experience with opioids. Now, opioids had been on the market for years and years and years and years. They had been available to doctors to treat severe pain, end-of-life pain, pain associated with terminal cancer, for example. But in December of 1995, something happened. I've got this this magnet board over here. You can see we've got a timeline, and so I'm going to use this to put up some milestones in what happened and what you're going to be hearing about in this case. So that's how we're going to kind of walk through some of this. And I told my folks to see if they could lower this easel a little bit. I'm hoping I can reach. We'll see. But there we go. Tiptoes. December of 1995, the United States Food and Drug Administration approves a medicine called OxyContin. And it approves that medicine for the management of moderate to severe pain. And what I'm showing you on the screen, you'll see in this case, this is what's called a product label or a package insert. This is the official statement that contains information about the medicine. Information including what it's used for, what it can be used for, risks, safety information, some chemical information about it, all kinds of stuff. And this is something, every single word of it, it's proposed by the group, or the company that manufactures the medicine, but it can't go on this piece of paper. It cannot go to doctors, it cannot go to nurses, it cannot go to pharmacists until the Food and Drug Administration approves it. Every single word. And I want to show you a little bit about what words were approved. First is this. This is the section of the label that says to doctors and nurses and pharmacists, what can you use this medicine for? What's it approved for? And what the FDA label said was that OxyContin tablets are indicated, that means approved for, they can be used for, the management of moderate to severe pain, where use of an opioid analgesic is appropriate for more than a few days. Analgesic means a pain medicine. So for the first time, December of 1995, we have official word from the Food and Drug Administration that an opioid, OxyContin, can be used to treat moderate pain, not just severe pain, and it can be used for more than just a few days. Now, even at this time, people understood that when you're dealing with an opioid, you got to be careful about the risk of abuse, the risk of addiction. People knew that. And this official statement actually addressed that as well. Whole section of this that talked about drug abuse and dependence or addiction. And here's what this official statement said about OxyContin, and this is what was given to doctors and nurses and pharmacists about this medicine. It said that delayed absorption is provided by OxyContin tablets. It's believed to reduce the abuse liability of a drug. What does that mean? Delayed absorption is, what it means is when you take the medicine, it doesn't all go right into your bloodstream all at once. You're going to hear about that. It works over time. And abuse liability of a drug, that means the propensity, or that's another big word, right? the probability or possibility that the drug could be abused. And here, the abuse we're talking about is addiction. And what this statement is saying is that because of this delayed release characteristic of OxyContin, the abuse liability, the potential for abuse, the potential for addiction is believed to be reduced. And that's not all. December 1995, this official statement about OxyContin also said that iatrogenic addiction to opioids legitimately used in the management of pain is very rare. All right, another one of these words, iatrogenic. I actually did have to look that one up. Iatrogenic just means it's something that is a reaction to your treatment. So, you fall on the ground, you open a wound, a scab or something, the blood that's coming out there, that's not an iatrogenic reaction, that's the injury. But if you put an ointment on that wound and you get an allergic reaction, that allergic reaction is what's iatrogenic. So here what they're saying is that addiction is a result of taking OxyContin. Those are legitimately used in the management of pain. Addiction is very rare. That's not Walgreens saying this. Walgreens had nothing to do with this. This is a label for a product made by Purdue. Statement, words, approved, every single one of them by the United States Food and Drug Administration. And so by December of 1995, you have a statement, FDA approved, that OxyContin can be used to treat moderate pain for more than a few days, and patients are less likely to become addicted to it. And that's a statement that the manufacturer of OxyContin, the company that made it, Purdue, they could use that to promote OxyContin to the groups that Purdue targeted. Doctors who were prescribing it, patients who were in pain. And you're going to hear in the course of this trial that that is in fact exactly what Purdue did. A few years later, we get to the next entry on our timeline. This one's a little bit lower down. I shouldn't have quite as much of an issue. 1999. In 1999, the Florida Board of Medicine, so when I just showed you that label, that's like all across the country. United States Food and Drug Administration. Well, here, 1999, I'm talking about something that happens here in Florida. Florida Board of Medicine, they adopt what's called a standard of care, a standard for the use of controlled substances for the treatment of pain. So we're not just talking about any old medicine, we mean controlled substances, that includes opioids, and we're talking about how you should use them, not just for any old purpose, but to treat pain. And here's what the Florida Board of Medicine told doctors in this state in 1999. Board of Medicine recognizes that principles of quality medical practice dictate that the people of the state of Florida have access to appropriate and effective pain relief. Board of Medicine here in Florida encouraged physicians to view effective pain management as a part of quality medical practice for all patients with pain, acute or chronic. And the board recognizes that controlled substances, including opioid analgesics, may be essential in the treatment of acute pain due to trauma or surgery or chronic pain, whether due to cancer or non-cancer origins. All right, let me summarize for just a second. A lot of slides so far, a lot of talking so far. Let's just take a step back and think about where we are. 1995, you have the FDA approving information, a medicine, OxyContin, that could be used to treat moderate pain, approved for moderate pain for more than a few days, and the risk of addiction is rare. 1999, the Florida Board of Medicine tells doctors, hey, you should really, there are standards now, and we encourage you to treat pain. People of the state of Florida are entitled to that treatment. And in the early 2000s, standards for certifying hospitals and other healthcare institutions, they also started to change and started to say you got to address pain if you want to get our stamp of approval. So you might expect that the use of pain management medicines, including opioids by this time, early 2000s, increased a lot in response to all of these developments, and the evidence is going to show that you'd be exactly right. Now, I told you that I would explain to you what the Office of the Attorney General has said about what's going on here and about what caused this shift in the perspective back in the 1990s and what was going on. And in the course of this case, ladies and gentlemen, you are going to learn something very important about what the Office of the Attorney General has said to the people of the state of Florida about what caused the opioid crisis here in Florida. You're going to see that the Attorney General, back in 2018, 2019, not all that long ago, put on her website statements, things that she said about what has caused the opioid crisis here in Florida. Remember, I urged you at the beginning to be thinking about what's being said by the Attorney General's lawyers here in court versus what has been said before. And what she has said, what the Attorney General's office has said, is that you got a group of these people who make opioids. And I'm putting them up on the screen for you here, different companies. She has said these are all companies that make opioids. Walgreens is not among them. No dispute about that. Here's what she has stated. She has stated that these companies used a campaign of misrepresentations to increase opioid prescriptions and opioid use among the general public. That's what the Attorney General's office has said. She has said that these companies caused the opioid epidemic by engaging in a strategic campaign of misrepresentations about the risks and benefits of opioid use to physicians, other prescribers, consumers, pharmacies, and state governmental agencies. Pharmacies. The Attorney General's office has stated that the manufacturers of opioids, the Purdue's of the world, the folks who make these opioids, that they caused this epidemic by misrepresenting the risks and benefits of their opioids to pharmacies. She's even stated what those misrepresentations were. There's a long list here. I'm not going to go through every one of them, but I just want to focus on a few. The Office of the Attorney General has said that these companies misrepresented the risks of developing opioid addiction, misrepresented the difficulties of preventing opioid addiction, misrepresented the dangers of high-dose opioid treatment, misrepresented that taking opioids long-term for chronic pain would lead to increased lifestyle benefits while omitting the risks of such treatment. And the Office of the Attorney General has stated that these companies, these people who make opioids, misrepresented that certain opioid products were less likely to be misused. You will hear in this litigation, in this lawsuit, in this trial, that we agree with the Attorney General about this. We agree. We agree that the manufacturers, folks like Purdue, they did misrepresent the risks and benefits of opioids, and they misrepresented them to us, to Walgreens. I want to focus for a moment on one particular manufacturer that Mr. Webster mentioned this morning, and that's Purdue. He spent a little bit of time talking to you about what he suggested was an inappropriate connection between Purdue and Walgreens. And I believe he's going to show you documents during the course of this trial where Walgreens asked for training and educational materials from Purdue about the prescription drugs that Purdue made. And I believe that the Attorney General's lawyers are going to suggest to you, I think you heard that this morning, that somehow that showed that Walgreens collaborated or conspired with Purdue to spread the message that Purdue is out there selling. But here's the thing, you've just seen that the Office of the Attorney General has said that pharmacies were lied to. Pharmacies were among those who were lied to by this campaign of misrepresentation undertaken by Purdue. Remember, this is the Attorney General's, the office's own words. The Attorney General, her own words, the Office of the Attorney General, she's even stated how they did it. Purdue, that is. She said that these companies, and that included Purdue, they used continuing medical education programs to spread misinformation. These CMEs, these continuing medical education programs, spread these companies' false messages to doctors under the guise of legitimate educational programs. The Office of the Attorney General has stated that these companies, that's Purdue, encourage their sales forces to misrepresent the addictive qualities of opioids through training programs. For example, the American Journal of Public Health noted Purdue trained its sales representatives to carry the message that the risk of addiction was less than 1%. You will learn over the next few weeks Purdue were carrying that message to Walgreens. They were misrepresenting that to Walgreens. So over the course of the next few weeks, when the Attorney General's lawyers present you with documents and other evidence that they say link Purdue and Walgreens, documents and other evidence that they say suggest Walgreens was doing something wrong when it arranged for and even attended educational seminars offered by Purdue back in 2000, 2001, I want you to remember what the Office of the Attorney General has stated outside of this trial. That Purdue caused the opioid epidemic by engaging in a strategic campaign of misrepresentations about the risks and benefits of opioid use to physicians, other prescribers, consumers, state government agencies, and pharmacies. And I want you, as you listen to the evidence on this point, I want you to ask yourself, is there anything in the documents or the testimony that the Attorney General's lawyers show you that actually demonstrates, unlike all the other doctors, all the other prescribers, all the other pharmacies, all the government agencies, that actually demonstrates that Walgreens somehow knew that Purdue wasn't telling the truth and that Walgreens went along anyway? Now, in this case, you're going to hear about something else that caused the opioid crisis here in Florida. This is a picture of something called a pill mill. Last week, I think when Mr. Stoffelmeyer talked to you a little bit about pill mills, asked you who's heard of a pill mill, not a lot of people raised their hands, but when he then talked about, they advertise on billboards, there seemed to be a lot more recognition, at least for those of you who've lived in Florida for a while, lived through this time. Pill mills are places like this. And the Attorney General's office has actually told us what pill mills are. Back in 2011, the Attorney General's office had a press conference about pill mills, and they actually defined it for us. They said pill mills are defined as a doctor's office, clinic, or healthcare facility that routinely conspires in the prescribing and dispensing of controlled substances outside the scope of prevailing standards of medical practice, or otherwise violates the laws regarding the prescribing or dispensing of prescription drugs. Now, sometimes you're going to hear pill mills referred to as pain clinics. You're going to hear that the owners of pill mills, the people who owned and operated them, they didn't have to be doctors. They didn't have to have any medical background at all. They didn't have to have any knowledge about prescription drugs. Remember what the Office of the Attorney General said. These were places where they actually prescribed and dispensed prescription drugs, even though people who owned them didn't have to know anything about that. Now you're going to hear in this case evidence that pill mills dispensed prescription medications, but that pill mill owners and the doctors who worked there, they weren't licensed as pharmacists. They weren't licensed to dispense. They were allowed to. And as a doctor, you'll see, they were allowed to for some period of time, and then that stopped. But none of them were pharmacists. You're going to hear that pill mills, unlike pharmacies, could advertise that they dispense narcotics. You can see that right here in this picture. But they could advertise on billboards. They could advertise in the phone book. That's not what pharmacies like Walgreens did or were allowed to do. You're going to hear that convicted felons owned and operated pill mills here in the state of Florida. And you'll hear that while the doctors who worked there at these pill mills, they had to be licensed by the Board of Medicine to practice medicine, the pill mills themselves, these businesses, they weren't regulated by the state of Florida at all for a very long time. And you're going to see evidence showing that most people outside of this courtroom agree that pill mills were one of the principal reasons why Florida found itself facing an opioid crisis. In fact, everybody in the courtroom even agrees on this. I'm putting up in front of you something that you're going to see quite a bit of, I think, in this trial. This is the Florida Attorney General's Prescription Drug Diversion and Abuse Roadmap. So this was put out by the Office of the Attorney General back in 2012. This is when Pam Bondi was your Attorney General. She published this. This was the roadmap that she put out there. And she explained right up front in the executive summary what this was. She said that it's a coordinated plan to systematically shut down pill mills and dramatically reduce the number of diverted pharmaceuticals flooding our communities. And Chapter 1 was all about pill mills. Talked about them as Florida's health and public safety emergency. Here's what the Office of the Attorney General said in 2012 about pill mills here in Florida. She asked, how did Florida become the epicenter of pharmaceutical drug diversion? Pain clinics exploded throughout the state because of a lack of sound pain management regulations. Lack of pain management regulations. It's the state that puts regulations in place. Unfortunately, while this epidemic grew, Florida failed to legislatively enact new standards of practice for pain management, and delayed implementing a statewide prescription drug monitoring program that 35 other states were already routinely using to help safeguard the integrity of their prescription drug delivery system. I'm going to get back to that for a second. I want you to hold on to that long term there. Prescription drug monitoring program. I think Mr. Webster talked about it just briefly this morning. He might have mentioned those 4 words, or PDMP. I'm going to come back to that. It's an important part of this case, and I want you to just hold on to that for a second, okay? But what this roadmap says is Florida didn't have one. Didn't have one. And then this roadmap says these key factors, as well as others, combined to make Florida the prescription drug tourism destination of choice. And the Office of the Attorney General even gave us kind of an example to show just how bad these pill mills had become. One popular illustration of how bad it eventually became in Florida is the oft-cited statistic that by 2009, there were far more pill mills in populous Broward County than McDonald's restaurants. All right, let's take another kind of time out for a second, step back for a second. Talked about a whole bunch of stuff now, right, about things that the Office of the Attorney General has said caused the opioid crisis, things that I've shown you and the evidence is going to show you. Let's just step back for a second. Talked about changes in the standards of how you treat pain, right? That doctors and nurses started looking at that a little bit differently. Talked about how the FDA approved OxyContin to treat chronic pain for more than just a few days. Talked about misleading promotion by opioid manufacturers, companies like Purdue. And we just talked about pill mills. Ladies and gentlemen, the evidence is going to show that Walgreens had nothing to do with any of that. Walgreens had nothing to do with any of that. So what did the state of Florida, what did the Office of the Attorney General do while this pill mill crisis was festering and growing? The evidence is going to show that the state of Florida and the Office of the Attorney General did nothing. Nothing. Now that's not to say that there weren't good people out there trying to sound the alarm. In September of 2001, next stop on our timeline, a gentleman named Dave Ehrenberg wrote a memo. And Dave Ehrenberg was an assistant attorney general at the time. A decade later, he actually rose to become basically Florida's drug czar. I'm going to tell you a little bit about that in a minute. But back in 2001, he was at the Attorney General's office. He was an assistant attorney general, and he wrote a memo. And his memo was titled, "The Florida Attorney General's Response to OxyContin Abuse." This is when Bob Butterworth was Florida's Attorney General. And he described the problem. He talked about OxyContin abuse. He knew that folks were abusing OxyContin. And he wrote a memo about it. And at the end of that memo, he had a section in there that had some suggestions about what should be done about it. And you're going to see that what Mr. Ehrenberg suggested were a few things. First, he suggested that Florida require all prescriptions for controlled substances to be filled through a central computerized data bank, excluding prescriptions for hospice patients and others in similar situations. So, if you have a prescription from a hospice deals, of course, with end-of-life issues, and folks recognize that, that was one of the things that was a legitimate use of these kinds of medications. So what Mr. Ehrenberg was saying was, we don't have to monitor that, the hospices necessarily, but we should require all other prescriptions for controlled substances to be filled through a central computerized data bank. Okay? Mr. Ehrenberg also suggested that the state establish a physician's education program for OxyContin through county medical associations. He suggested that the Attorney General's office focus its efforts on the controversial pain management clinics, those pill mills, from which OxyContin is often prescribed. And he suggested that they increase penalties for violators. For example, he said Florida could amend its statutes to clarify the crime of doctor shopping to procure additional prescriptions. Florida could make it a crime to go around and shop for doctors who would just give you more opioid medication. Florida could do that. He suggested that was something they could do. But these calls for action, these suggestions, they went unheeded, ladies and gentlemen. From 2001 to 2009, the evidence is going to show that nothing was done. The state of Florida didn't pass any laws to address this. The Office of the Attorney General didn't make it a priority, didn't focus on this. 2001 to 2009. And how do we know that nothing was done? Well, you're going to see a document. This is a timeline, or something prepared by Attorney General Moody, or her office at least. Her office put this timeline together. It's called Milestones in Florida's Opioid Battle. And you can just see right there that the very first entry in that list of milestones in Florida's opioid battle is 2009. Now you're going to hear from Mr. Ehrenberg in this case. We look forward to having you hear from him. I told you before, he's the one that wrote that memo back in 2001. I said that a little bit later on, 2010, he actually became the state of Florida's special prosecutor for prescription drug trafficking. And we had an opportunity to ask Mr. Ehrenberg some questions about his experience during that time, his perspective on that time. And you'll hear a lot more from him. This is one of these depositions that you heard Mr. Webster describe a little bit about. I want to preview his testimony for you by just sharing a little bit of it with you now.
Florida was aware of the pill mill problem at least as early as the early 2000s. Is that right?
Yes.
And legislation wasn't passed to address it in any way until 2010, correct?
Correct. I don't recall the year that PDMP passed. It may have been in 2010 as well, but it's possible that was a year earlier.
So, would you agree that for years, Florida allowed convicted felons, including felons that had been convicted of crimes involving drug trafficking, to own and operate pill mills?
Yes.
And that for years, Florida allowed anyone to own a pill mill or pain clinic. Did not have to be a doctor or a medical professional, correct?
Correct.
And that for years, Florida did not require background checks on the owners or operators of the pill mills?
Correct.
And that for years, Florida allowed these non-doctor owners and operators to choose and hire the doctors that worked in the pill mills, correct?
Correct.
And for years, Florida allowed doctors who had been disciplined by a medical regulatory board to work in pill mills?
I believe that's correct.
And would you agree that for years, Florida allowed doctors without full, active, unencumbered licenses to work in pill mills?
I believe that's correct. Because I don't believe there were any restrictions on pill mill ownership or involvement until we finally was able to get legislation passed in 2010 or around that time.
So when Florida finally did act, what did it do? Well, I'm going to preview for you 4 things. 2009, it authorized that prescription drug monitoring program. 2010, the Department of Health here in Florida was authorized for the first time to inspect pill mills. 2011, something called the Pill Mill Law was enacted. And in 2011, a little bit later on that year, the prescription drug monitoring program that had been authorized in 2009 finally became operational. We just briefly go over each one of those. Next stop on our timeline, right? 2009. Florida authorizes the prescription drug monitoring program. And remember, back in 2001, when Mr. Ehrenberg wrote that memo about OxyContin abuse, and one of his ideas was, hey, let's require all prescriptions to be filled through a central computerized data bank. You will hear that that sounds an awful lot like PDMP, Prescription Drug Monitoring Program. But it wasn't even authorized by the Florida legislature until 8 years later. So what is the PDMP? I told you I'd kind of come back to that a little bit. Why is that so important? Well, it's a way you will learn to track and monitor the prescribing and the dispensing of prescription drugs here in the state of Florida. It's one database that doctors and pharmacists could go and check to see their patients' prescribing and dispensing history. Let me give you an example. A patient has a back injury, or at least claims to have a back injury. That patient goes to Dr. Smith on Monday. Dr. Smith prescribes that patient a 30-day supply of OxyContin. 3 days later, on Thursday, that patient goes to Dr. Jones. Doesn't tell Dr. Jones that he already saw Dr. Smith, but Dr. Jones gives him a 30-day supply of OxyContin. And you know what? After the weekend, that next Monday, that patient goes over to Dr. Wilson. Dr. Wilson gives him the 30-day supply. And to get these prescriptions filled, our patient goes to 3 different places, right? Let's say Monday takes Dr. Smith's prescription over to one of the national chain pharmacies, Walgreens, CVS, or maybe a Florida place like Publix. And 3 days later on Thursday, he takes that prescription that Dr. Jones wrote, brings it to a mom and pop pharmacy, one of the independent pharmacies, not affiliated with any chain, smaller place. And then the next Monday, he takes Dr. Wilson's prescription and actually goes to a pill mill to get it filled. Now, before there was a prescription drug monitoring program in place here in Florida, there was no way for any of those doctors or any of those pharmacists to know that this patient was doctor shopping. But once you have that PDMP, doctors and pharmacists, they could go to the computer, they could check, and they could see that in fact this patient was doctor shopping. And they could make their prescribing and their dispensing decisions armed with that important information. So 2009, the Florida legislature authorizes Florida to start a PDMP. But it didn't get operational then. It wasn't up and running then. Second thing that happened is in 2010. In 2010, the Department of Health, Florida Department of Health became authorized. It got authorization to actually go out and inspect these pill mills. They didn't have that ability before. Department of Health. And we took a deposition of a wonderful woman, Susan Love. That's her picture up there. She used to be, she's retired now, but she used to be the chief of the Bureau of Enforcement at the part of the Department of Health that was in charge of doing this stuff, called the Division of Medical Quality Assurance, all this alphabet soup of acronyms. But she was at the Department of Health, and I asked her about this moment in time when the legislature authorized Florida's Department of Health to go and actually inspect pill mills. I asked her, do you remember one way or the other whether for you this was a big deal? That is, gaining the ability, the authority to investigate pill mills and pain clinics. And Ms. Love said yes. I asked her, well, why was it a big deal? And she said, prior to that time, we had no authority, couldn't do investigations or inspections. Department of Health. So I asked her, why did it become a big deal for you to get that authority, to be able to investigate pill mills and pain clinics? Why was that authority important to you? She said, because it would help combat overprescribing. The evidence is going to show you that she was right. This is a report from that Department of Health, Division of Medical Quality Assurance from 2012, talking about what had happened over the past year. And in that report, they actually referred to pain management clinics and the legislation that gave them the authority to go and inspect and required these pill mills to register with the Department of Health. And what the Department of Health reported was that they had administratively closed, accepted the relinquishment of, or closed by enforcement action, 839 pain clinics here in Florida. You'll learn they couldn't do that before they were authorized by the state to do that. Third action. In 2011, July I think it is, State of Florida passes landmark legislation, you'll hear, the pill mill law. And remember that roadmap that the Office of the Attorney General put out in 2012? The Office of the Attorney General actually talked about this legislation. She said that a major step forward in systematically rolling back prescription drug diversion and abuse was the passage of HB 7095 during the 2011 Florida legislative session. HB 7095, that's known as the pill mill law. And what the Office of the Attorney General said about this was that it was a significant piece of legislation. It banned dispensing of Schedule II and Schedule III controlled substances by physicians. Banned dispensing of opioids by physicians. Now, why was that important? Well, remember, before this, if you were operating a pill mill or a legitimate clinic, but the pill mills were able to both prescribe and dispense. And you'll hear in this case about the role that pharmacists play to make sure that a prescription is written for a legitimate medical purpose. Well, if there's an unscrupulous doctor at a pill mill who's writing a prescription that he or she knows is not for a legitimate medical purpose, and that doctor's the one dispensing it, you got no one there to look at that and say, hey, was this prescribed for a legitimate medical purpose? Because that same doctor's going to say, yeah, of course it is. I prescribed it. Well, this law suddenly made it not possible for doctors to dispense the controlled substances that they were prescribing. You're going to hear about how critical this was in the fight against the opioid crisis here in Florida. Finally, we are back to that PDMP, the Prescription Drug Monitoring Program. Took them 2 years. But in 2011, in October, the PDMP becomes operational. Again, back to that roadmap, the Office of the Attorney General told us that at the end of 2011, Florida successfully launched its PDMP, which is a crucial component in our efforts to combat prescription drug abuse. You are going to hear, ladies and gentlemen, that Florida was one of the last states to adopt a PDMP. So almost a decade after Mr. Ehrenberg back in 2001 alerted the Office of the Attorney General to the problem of prescription drug abuse, the state of Florida does something. And the evidence is going to show you, by the way, that there was nothing during all of this time, there was nothing that prevented the state of Florida or the Office of the Attorney General from taking these steps. Now remember what I said to you this morning when I began, this morning, it seems like this morning, it's really this afternoon. Pay attention to whether what someone says inside the courtroom here is the same as what's said outside the courtroom. What did the person whose office filed this lawsuit, when we were told we were being sued by the Office of the Attorney General, it was Attorney General Pam Bondi who was the Attorney General of Florida at that time. What did she say about the cause of Florida's opioid problem outside the courtroom? Well, Attorney General Bondi, back in March of 2012, went up to Washington, D.C., and she testified in front of the United States Congress. She testified at the House of Representatives. And this is her statement. This is what she said to the men and women of the United States Congress. She said that Florida became the epicenter of prescription drug diversion because, here's the cause. She said that happened because until recently my state had weak regulatory oversight of pain management practices, limited oversight of physician dispensing habits, and no statewide prescription drug monitoring program. That's what she said back in 2012. And you didn't have to be a member of Congress to learn what Attorney General Bondi thought about Florida's opioid crisis, because she also talked about it on the news. Let me show you what she said on the news.
He used to talk all the time about illegal drugs, but there are legal drugs, prescription drugs, that are a huge problem, especially in Florida. We're exporting them. And I know as Attorney General that you have been seeking legislation to address this very real problem. It's called the Till Mill legislation. Update us, please, on where all that is.
Absolutely. And we have legitimate, good pain management doctors for terminally ill patients, for people with chronic pain. That's not what these guys are. They're drug dealers wearing white coats. And your typical pill mill is a business, and there's a line wrapped around the building. It's cash only, $200 to $300. All these bad doctors are doing is sitting in the back and writing prescriptions. And, there are no laws in Florida to fight these things. And so they're popping up on every corner. They typically have armed guards because they're dealing in so much cash. And what's happened is Kentucky, all the other states, the majority of the states, have the prescription drug monitoring program along with tough laws. The PDMP is just one small component of tough legislation.
What's PDMP stand for?
Prescription drug monitoring program. And in Florida, we didn't have the monitoring program, nor did we have tough laws in place to go after these guys. And that has been my really mission since I have been elected, working hand in hand with the House, with the Senate, with Speaker Cannon, with President Herodopoulos, Representative Shanks, Senator Fasano, and the governor. And we've really all been working well together to get some tough legislation passed. In 6 months alone, in Broward and Palm Beach County, they prescribed 9 million oxycodone tablets. And that is unacceptable. And it's been unreal. They say the numbers right now are 7 people a day are dying or overdosing from prescription drug abuse. We think when the new numbers come out, it's going to be even higher.
As you've looked into this problem, the question occurs to me is how in the heck could it have gotten this big and nothing has been done about it?
And that's a great question, and that's been the problem in Florida. We've had no tough laws, but now we're all working together and we're all fighting together because we are the epicenter of the country for prescription drug abuse.
Here's the thing. During all of this time, up through like 2009, Walgreens and its pharmacists, we weren't seeing all of the patients coming through our door that were going to the pill mills or that were going to legitimate doctors because those doctors could dispense. We weren't seeing that. Why go to Walgreens if you're a pill mill person? Why go to Walgreens and risk the pharmacist saying no if you know you can get it from your doctor? I'm showing you here something you'll see actually from the plaintiff's witness in this case, a guy named Craig McCann. And he put a chart together. He looked at Walgreens distribution and dispensing of oxycodone. And these are dosage units you see on the left here and years down on the bottom. So he charted it. He had data, I think, from 2006 to 2021. And so this is a chart that I think if he comes to trial, he'll show you, showing the numbers of dosage units that were dispensed at Walgreens pharmacies in Florida during that time period. And what I've done is I've taken our magnet board, I've actually put it up here on the screen electronically, and I've put that chart from Mr. McCann up against the timeline so you can kind of see what was going on in the state of Florida at the time that all of this was happening. And you're going to find out, the evidence is going to show you that, I mean, obviously you can see this really big jump here, right? You can see that from the end of 2009 up through 2011, middle of 2011, the numbers went up. The evidence will show you that there's a reason for why that happened. The evidence will show you that these are the years, as you can see, when Florida finally decided to start addressing problem of OxyContin abuse, the problem of pill mills. And remember, one of the things that Florida did was pass that pill mill law that made it illegal for doctors to both prescribe and dispense. And while that was aimed at pill mills, that prohibition applied across the board. And you can even see back in 2010, suddenly the Department of Health can go out and inspect these pill mills. That, you will see, had a sobering effect on the pill mill business. And what you're going to hear, ladies and gentlemen, is that this dynamic, what was going on during this time period, this put our pharmacists in a very difficult position. They had to find that balance that we've been talking about, that balance between preventing diversion on the one hand and ensuring that legitimate patients receive the medical help that they need. And even the Office of the Attorney General, you will see, recognizes the importance of that balance. In her roadmap in 2012, she said that the roadmap itself has to be balanced, is balanced. Because while we reduce illegal diversion of pharmaceutical drugs, we must still ensure that people legitimately suffering from chronic pain, crippling anxiety, or other debilitating illnesses can get the relief that they need. You're going to hear that our pharmacists were stuck in the middle. And that was a difficult place to be. Make no mistake about that. You're also going to hear that the state of Florida did not give our pharmacists any tools to address this until they made the PDMP available in October of 2011. You're going to hear that patients and doctors actually threatened to sue our pharmacists if they didn't dispense their opioids. You'll hear that patients tried to bribe our pharmacists, even after our pharmacists refused to fill their prescription. And you're going to hear that patients made physical threats of violence against our pharmacists when they said they wouldn't fill their prescription. Now, you're also going to hear that Walgreens acted. Walgreens took action. What you're going to hear from our pharmacists and from the folks at Walgreens who lived through this here in Florida on the ground is that unlike the state, Walgreens stepped up and put measures in place to try to deal with this flood of pain management prescriptions. I think Mr. Webster this morning said that Walgreens did nothing. Turned its back, put its head in the sand. You will hear otherwise. You will hear otherwise from the Walgreens folks who lived through that time period. You're going to see that we put action plans in place to reduce the dispensing of these controlled substances. We put guidelines in place for the appropriate dispensing of oxycodone. We had whole districts that would adopt action plans for the entire district. You're going to hear that we actually went and met with the DEA. We met with them in an effort to try and get some tips and suggestions on how to better handle the large amount of oxycodone scripts that we were receiving. And you are going to hear, ladies and gentlemen, that we at Walgreens were allies of law enforcement. We were their partners. Attorney General Bondi put a press release out in 2013. And in that press release, she was touting the sentencing of one of these pill mill doctors. And she said, she's talking about that prosecution sentence to 25 years, $500,000 fine. How'd that come about? Attorney General Bondi told us they acted on information provided by Walgreens. She's quoted in this press release. This pill mill doctor is no longer funneling prescription drugs into our communities thanks to a great collaborative effort beginning with Walgreens Pharmacy, reporting prescriptions using a revoked DEA number, stated Attorney General Pam Bondi. So when that problem first appeared at our front door, when all those prescriptions for opioids that have been filled by pill mills and pain management clinics, and legitimate clinics as well, filled by legitimate doctors, when all of those showed up at our front door, when all those prescriptions showed up at our pharmacy counter, we acted. And I think the evidence is going to show you that our actions were effective. Even Mr. McCann's data shows you that as quickly as those dispensing numbers went up, they went down. And you're going to see that the numbers started falling. Let me see if I can use this pointer here. The number, I can't really see it there, maybe, but there we go. The numbers started falling, right? Where's that crest? Where does that happen? Right around the time that Florida made the PDMP available to pharmacists and doctors. And the evidence is going to show you that PDMP, that's a tool that only the state could provide because it collected information from across the state, from all pharmacies, from all doctors that participated in it. All right, everybody still with me? The Attorney General, the Office of the Attorney General, her lawyers, they're going to put a case on that says that it was our policies, our corporate policies. I think you heard that a number of times this morning. Corporate policy. Corporate policies were to blame for the opioid crisis. They're going to tell you that they're not going after Nick. He's not their target. And I referred to corporate policies a little bit before in my presentation, but because that's going to be such a focus of our time together, I want to return to those for just a moment. And the first thing I actually want to do with you is preview for you, not Walgreens policy. I want to preview for you what the standard for dispensing pain medications in the state of Florida was. Because the state of Florida's Board of Pharmacy had a standard that addressed this very issue. In 2002, Florida Board of Pharmacy adopted this standard. Standard of practice for the dispensing of controlled substances for treatment of pain. And here's what it said. Board of Pharmacy recognizes that principles of quality pharmacy practice dictate that the people of the state of Florida have access to appropriate and effective pain relief. The board recognizes that inappropriate dispensing of controlled substances may lead to drug diversion and abuse by individuals who seek them for other than a legitimate medical use. pharmacists should be diligent in preventing the diversion of drugs for illegitimate purposes. Remember I said before that you're going to see that people understood when you're dealing with opioids, you got to be careful because they are prone to abuse and addiction. Here, the Board of Pharmacy is saying, look, people in the state of Florida have a right to pain management, but we're also recognizing that inappropriate dispensing could lead to diversion and abuse. And so what the standard you will see, what it goes on to do, is it actually sets forth criteria that should cause a pharmacist to question whether a prescription was issued for a legitimate medical purpose. Now, Mr. Webster this morning spent quite a bit of time in his slides and everything, a lot of red in those slides about red flags. Red flags. He didn't tell you where they came from, who established those red flags. I'm about to show you the red flags that are in the Florida Standard of Practice. This was adopted in 2002. And let me preview for you that you will hear that the red flags that Mr. Webster was referring to are not these. They're different red flags. I'll get to them in just a bit. Standard of practice from the Board of Pharmacy. Here's what it told Florida pharmacists, starting in 2002. If you have a patient who frequently loses their controlled substance medications, that's a red flag. You should question that. Look further into it. If you have a patient who only is prescribed controlled substance medications, that's a red flag. Look into it. If you have one person who comes to your pharmacy counter who presents controlled substance prescriptions with different patient names, red flag. If you have the same or similar controlled substance medications that are prescribed by 2 or more prescribers at the same time, that's a red flag. And number 5, if you have a patient who's always paying cash or always is asking for the brand name product, that's a red flag too. That's the Florida Standard of Practice. 5 red flags that are called out. Here they are. And the Standard of Practice even told Florida pharmacists like Nick what to do if you get a prescription that has a red flag. 2 steps, you were told. 1, request the patient's photo ID. And if they have a photo ID, you should make a copy of it. And if they don't have a photo ID, well, you should confirm their ID by some other means. I imagine that probably means, if you know the person from the block party down the street, right, you live in the community, that could be a way to confirm their identity. And then you're supposed to kind of jot that down, how do you confirm that? That's step 1. You got to confirm their identity some way or another. Patient. Step 2, and remember, these are steps that the Florida Board of Pharmacy standard tells you to take only if there's a red flag, one of these 5 red flags. Step 2 is, you got to call the doctor. Call that doctor to verify the prescription. And if the doctor picks up and says, yep, I'm verifying that prescription, you can dispense it. But if the doctor's not available, this standard said you still could dispense it. You can dispense a 3-day supply. Even if the doctor doesn't verify, you can dispense a 3-day supply. And if you find they do reach the doctor and the doctor does confirm the validity of the prescription, then you can dispense the rest of it. That's it. You will see that that was the Florida Standard of Practice, and it was the Florida Standard of Practice for all this time that we're talking about here, up here on the board. All right, that's Florida. What about Walgreens policies? Remember, those are what the Attorney General and her lawyers are aiming at. What were Walgreens policies in this regard? Well, in 1998, I told you we had a good faith dispensing policy. Here's what it said. I showed you a little bit about it before. Comply with state law. So right off the bat, anything that's in that Florida standard, it's in our standard as well. Got to follow state law. We actually added additional red flags, different red flags. Got to follow those 5 because that's part of state law, but we had other ones in there as well. If a red flag is present, don't dispense. Don't dispense. That's 1998. We updated our policy, ladies and gentlemen, in 2006. We added more to it. We said if a red flag is present, go ahead and call the prescriber. It wasn't just don't dispense, it was call the prescriber. Document whatever validation the prescriber gave to you. And if the prescriber is unavailable, do not dispense. Not even a 3-day supply. Don't dispense if you can't reach the prescriber. 2011. We update our policy again. We add more red flags. We tell our pharmacists in no uncertain terms that if you violate this policy, you will be subject to discipline up to and including losing your job. 2012. Another update. More red flags. We tell our pharmacists you must use the PDMP if it is available in your state. And we tell our pharmacists that validation by the doctor, that's necessary, but it's not sufficient. You as a pharmacist still have to exercise your own independent, individual good judgment, even if the doctor verifies it, to determine whether you are going to dispense that medication. So the evidence, as we show it to you in this case, will enable you to take a look at kind of the differences between Florida's standard and Walgreens' policy. You had red flags that were identified in that Florida standard, same in Walgreens. If you see a red flag, call the prescriber. Florida required that, Walgreens required that. But only Walgreens had additional red flags beyond those 5. Only Walgreens required our pharmacists to document the validation they got from the prescriber. Only Walgreens said that if the prescriber is unavailable, do not dispense. Only Walgreens said that that validation from a prescriber, that's not sufficient to dispense. And only Walgreens told its pharmacists that you've got to use the PDMP. Why do I say that? Florida finally made the PDMP available to pharmacists and doctors in 2011, but waited 7 more years before they made it mandatory. So if you're a pharmacist or a doctor between 2011 and 2018, it's a good idea to take a look at that PDMP, but you weren't required by the state of Florida to do that. Walgreens' policy did require our pharmacists to do that. Remember, the key aspect of our policy, we're talking corporate policies here, was that the pharmacist always must use the elements of good faith dispensing in conjunction with state and federal controlled substance laws. When filling all prescriptions, the pharmacist must ensure that a prescription for a controlled substance is dispensed for a legitimate medical purpose. If you cannot validate that it's a legitimate prescription, don't dispense. Were we perfect? No. No, we were not perfect. As you're going to hear, this was an incredibly difficult situation into which our pharmacists were placed. Now, don't get me wrong, ladies and gentlemen. We are very proud to be on the front lines here in Florida. And in Florida, we are on many of those front lines. And our policies, our procedures, what I just showed you, those were sent to every single one of those stores. They were sent to every single pharmacist. And it was a requirement that those stores and those pharmacists follow those policies. But are there situations where, in hindsight, another pharmacist might have made a different decision about dispensing a pain medication? I'm sure there are. But you're going to see in this case that we don't need to rely on hindsight to determine whether our pharmacist judgment calls on dispensing were overwhelmingly right, or as the Office of the Attorney General and her attorneys, her lawyers now allege, whether they were so overwhelmingly wrong and so widespread all across Florida that we created and we fueled a statewide opioid crisis. Now you've seen what the Attorney General said, Attorney General Bondi, back in 2012 about what caused this statewide crisis. And you've also seen what the Office of the Florida Attorney General has stated about what caused this opioid crisis. It was the manufacturers, the companies that made the opioids, that misled everyone else, including pharmacies. But that's not all. Mr. Webster referred you to a DEA investigation here in Florida. That's the Federal Drug Enforcement Administration. They did conduct an extensive investigation of their own, of Walgreens here in Florida. That was conducted here on the ground, out in the field, DEA agents visiting Walgreens pharmacies. And at the conclusion of that investigation, Walgreens and the DEA reached a resolution. Part of that resolution involved whether Walgreens pharmacies would be allowed to continue to dispense opioids. And what the DEA and Walgreens agreed is that Walgreens would stop dispensing opioids and controlled substances generally, stop dispensing for a period of 1 year at 6 pharmacies. 6 pharmacies. Now, the Attorney General, plaintiff here, is going to suggest to you that this shows that Walgreens is at fault and is to blame for the opioid crisis throughout the state of Florida. I think that the evidence is going to show something else. You're going to see that it shows that Walgreens accepted responsibility for these 6 pharmacies, and that the overwhelming majority of our pharmacies and our pharmacists were doing their best to achieve that balance that we've seen the Attorney General herself say is important. Reducing illegal diversion while at the same time ensuring that people legitimately suffering from pain, crippling anxiety, or other debilitating illnesses can get the relief that they need. All right, one last recap. We've talked about why there's so many pills. We've talked about what the Office of the Attorney General itself has said caused the opioid crisis. We've talked about what Florida did do and did not do in response to that crisis, and now we have focused quite a bit on dispensing. What Walgreens has done on those front lines at the pharmacy counter. I want to turn now to one other part of the case that Mr. Webster talked to you about that will be part of this case, and that has to do with distribution. Remember earlier today we went through this and I talked about the different roles that folks play. We're not the manufacturers, we're not the doctors, and we were distributors up until about 8 years ago. We did do that. That's another role that we played. And there are 2 points that I'd like to preview for you about distribution. First one is what I mentioned to you before. When Walgreens distributed prescription medications, it distributed them only to its own pharmacies. Remember that, self-distribution. Now, why is that important? Now, you're going to learn that when you're a distributor, you should know your customer. Know your customer. That's why self-distribution is so important. We know our customers. Our customers are our pharmacies. And this point about self-distribution is important because it actually distinguishes us from the other companies that distributed opioid medications in the state of Florida. You'll recall I discussed with you these other opioid manufacturers that the Office of the Attorney General has stated, caused the opioid crisis. Well, the Office of the Attorney General has also stated that there are distributors that caused the opioid crisis. Distributors like McKesson, AmerisourceBergen, and Cardinal Health. And here's what the Office of the Florida Attorney General has stated about them. She said that those companies' unlawful diversion of opioids is a direct and proximate cause of and/or substantial factor leading to the opioid epidemic and all the past and ongoing damages, incurred by the state of Florida. I told you that these distributors, they're different from Walgreens. And that's because these distributors, they don't just distribute to themselves. These are the ones that distributed to the pill mills. These are the ones that distributed to rogue pharmacies, new term that I haven't mentioned before. You'll hear about that later. The Attorney General in the roadmap described rogue pharmacies as pharmacies that pill mills actually set up as independent businesses, kind of just down the street, but they were just serving the needs of the pill mill. These other distributors, they sent opioids to those rogue pharmacies. They sent them to internet pharmacies. Used to be that you could real easily get any medication you wanted over the internet. Walgreens never sent to any of these places, never distributed to any of these places. And as you will see, it's these places that then put the opioids out into Florida and that caused the damage that's being claimed in this case. Now, the second point that I want to preview for you is I want to introduce you to this gentleman. This is Greg Anderson. Now, Greg worked for 28 years at the DEA. And I look forward to introducing you to him and to having you hear about his long career at the DEA. Greg's going to talk to you about the system of controls that all distributors are supposed to have, about how they need to monitor for certain kinds of orders of controlled substances. He's going to explain the systems and the controls that Walgreens had in place at its distribution centers and how Walgreens maintained effective controls against diversion. And he's going to explain how, even though Walgreens stopped distributing in 2014, stopped distributing controlled substances 8 years ago, Walgreens still operates a system to see what kind of orders for opioids are being made by its pharmacies. Now, Mr. Anderson's going to tell you Walgreens isn't required to do that. No one told Walgreens to do that. But we're doing it anyway. And that's because you will learn if there's a problem at a Walgreens pharmacy. If a Walgreens pharmacy is placing orders for opioids that don't make any sense for a pharmacy of that size or in that location, Walgreens wants to know about it so that it can examine what's going on and take appropriate action. All right. You're always told, never say I'm on my final point if you're really not on your final point, because people will hold you to it. This is my final point. This is the final part of my opening statement to you. But it's a really important one. It's a really important one. I know you've been sitting for a long time, and I really appreciate your patience, but I ask you to focus especially on this. You will learn that it is the plaintiff here, the Office of the Attorney General. They're the ones who bear the burden of proving to you that Walgreens' conduct produced or substantially contributed to the injury that the plaintiff is claiming here in this lawsuit. So how is the plaintiff going to do that? I think you got a little bit of a preview of that in a number of the slides that Mr. Webster showed you this morning, because he really focused on this concept of red flags. Red flags. Red flags we've discussed before, right? These are something that should cause a pharmacist to question whether a prescription was issued for a legitimate medical purpose. And what the plaintiff is going to rely on is a red flag analysis of the prescriptions that Walgreens filled here in the state of Florida from 2006 to 2021. And that red flag analysis, all the red flag stuff that Mr. Webster talked to you about this morning, all those numbers, I think you mentioned millions or something like that, they all come from an analysis that will be presented to you by this guy. This is Paul Doring. He's been hired by the plaintiffs here to do this red flag analysis. He's a pharmacist, but you're going to learn that Mr. Doring was first licensed as a pharmacist in 1973. And you're also going to learn that Mr. Doring, he hasn't filled a prescription for an opioid here in Florida since 1973 or 1974. Mr. Doring stopped dispensing 1 year after he got his license. I mean, his career as a dispensing pharmacist, you'll learn, was essentially 1 year. And that 1 year was 50 years ago almost. 50 years ago, when Richard Nixon was our president, and when some of you weren't even born. Now you're going to learn also that Mr. Doring's license to practice pharmacy here in the state of Florida, that expired in 2017. Here's some other things you're going to learn about Mr. Doring when he comes to testify. He didn't visit any Walgreens pharmacy to do his red flag analysis. He didn't talk to any Walgreens pharmacist to do his red flag analysis. And unlike the pharmacists who evaluate and dispense the prescriptions, Mr. Doring, you will learn, had no interaction at all with the patient, and and no knowledge of the surrounding circumstances of when that prescription was filled. Now what Mr. Doring did do is he came up with his own list of red flags. His own list. And then he had someone run a computer program that identified any prescription filled by Walgreens that hit on any of those red flags. And when Mr. Doring comes in here to testify, we're going to ask him about his red flags. And I'm going to want you to pay close and careful attention to those red flags. And I'm especially going to want you to compare his list of red flags to the 5 red flags that were in the Florida standard of practice for Florida pharmacists to follow here in this state. I think you're going to see that Mr. Doring's red flags are quite different. And again, you will learn that all the evidence about the millions of red flags, that comes from Mr. Doring and his list of red flags. Now we're also going to introduce you to someone named Bob Parado. Bob Parado actually took a look at the red flags that Mr. Doring came up with. Bob Parado, first of all, he's lived in Tampa his whole life. He's been a registered pharmacist since 1971. In fact, his career was just getting started around the time that Mr. Doring stopped working as a practicing pharmacist. Mr. Parado's been a pharmacist for 50 years. He practiced pharmacy behind the counter for more than 40 of those years. He's the former chair of the Florida Board of Pharmacy. He's the former president of the Florida Pharmacy Association. And he's a board member of the Hillsborough County Anti-Drug Alliance right over there in Tampa. And he's going to explain to you how things work in real life when you're really behind the pharmacy counter as a practicing pharmacist. He's going to walk you through those red flags of Mr. Doring, and he's going to explain to you why they capture many situations that would not raise a concern for a real pharmacist in Florida exercising his or her professional judgment. He's going to show you, in fact, that if you took Mr. Doring's list of red flags and you looked at the prescriptions that were written and filled at Walgreens, written by some of this state's top doctors. I'm talking about doctors on the Board of Medicine, doctors on the Board of Pharmacy's Controlled Substances Committee, doctors who've been appointed by the Attorney General to serve on her opioid working group. If you used Mr. Doring's red flags and applied them to the prescriptions filled at Walgreens that were written by those doctors, over half of them would be flagged as suspicious. So either that means that these top doctors in the state are practicing outside of the legitimate medical use for these substances, for these drugs, for these pills, for these medicines, or it means there's something fundamentally wrong about Mr. Doring's red flag analysis. Now, even though, well, let me say this, even Mr. Doring is going to acknowledge that just because a prescription hits on a red flag, it does not mean that it should not have been dispensed. It means that the pharmacist should look more closely at that prescription. That's what it means. And you're going to learn that Mr. Doring, he never did that. He didn't do the follow-up work that a pharmacist does to determine whether a prescription that hits on a red flag should or should not be dispensed. The evidence is going to show that it takes a real-life, practicing pharmacist to do that. And we look forward to having you hear from our pharmacists about how they make those real-life determinations behind the pharmacy counter each and every day, just like Nick does there at 9220 Little Road. All right, I told you that was my last point. It really was. We're about to start the evidence in this case, ladies and gentlemen. And as you listen to that evidence, I ask that you keep a few questions at the front of your mind. Question number 1. What were the standards that the state of Florida itself told Florida pharmacists they needed to meet when they were dispensing pain medications like prescription opioids? Number 2, what did the Attorney General and those who represented her say out in the real world before she filed this lawsuit about what caused the opioid crisis here in Florida? 3, what has the Office of the Attorney General said about the causes of the opioid crisis when she has spoken through press releases regarding the role of manufacturers, the people who make opioids? What has she said, what has her office said about their role here and whether they caused this crisis? Number 4, will the state accept responsibility for the impact that its actions and its inactions, its failures to act, will the state accept responsibility for those failures and the effect that they may have had on causing or contributing to the opioid crisis here in Florida? I want you to think about that as you hear the evidence. And finally, did Walgreens pharmacists here in Florida, did they confront an opioid crisis when it appeared at their pharmacy counter by trying to do the right thing? By ensuring that patients who were experiencing real and often debilitating pain, that they got the medicines that they needed prescribed by their doctors, while at the same time guarding against folks who wanted to divert those medicines to improper uses. Those are the 5 things I'd appreciate you keeping at the front of your mind as you're listening to the evidence. The next time that we get to talk to you directly like this, it's going to be after all the evidence is in. And we look forward to that. And after you hear all of the evidence, we're going to ask you to return a verdict for Walgreens. On behalf of our team, my partner Casper Stoffelmeyer and our colleagues, but especially on behalf of the men and women of Walgreens here in Florida, and particularly on behalf of Nick Vasilakos and the pharmacists who work every day behind the pharmacy counter here in Florida, I want to thank you. I want to thank you for the time and the attention that you are giving this case. It's an important case for Walgreens. And I'm sure it's an important case for the state as well. And we look forward to spending the next few weeks with you, to presenting the evidence to you, and to talking with you at the end of the case. Thank you very, very much.
All right, we're going to take an afternoon break, so we'll be in recess until 3:30. Again, you are free, so we do have choices, and maybe not today because we've been going a long time, so I'm probably going to let you just go outside. Hopefully there's vending machines out there, but at some point during the trial, we will take shorter breaks and you'll be able to go into the jury pool room and use the restrooms in there and things like that. But today we're going to take a little bit of a longer break, and that way you can go if we need, the vending machine, drink or coffee or something like that. You can go get that. All right, so again, I'm talking about the case, leave your notes, and be back outside here, upstairs, down the hall at 3:30.
David T. Courtwright as his first witness.
All right.
Courtwright.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
Good afternoon, Dr. Courtwright. Can you please state your name for the record?
David Courtwright
Where do you live?
in Jacksonville, Florida.
How long have you lived there, Dr. Courtwright?
I've lived there since 1988.
Dr. Courtwright, how old are you?
I just turned 70. Yesterday was my 70th birthday.
Happy birthday, Dr. Courtwright.
Thank you.
Did you supervise the preparation of any slides today?
I did.
Why did you do that?
Oh, as demonstratives for the jury.
Jack, can you put on the slides? Are these the slides you prepared, Dr. Courtwright?
They are, yes.
What is your graduate degree in, Dr. Courtwright?
It's in history.
Where did you get your PhD from?
I received my PhD from Rice University
And when did you get your PhD?
in 1979
What was your PhD in?
in history.
Where do you currently work, Dr. Courtwright?
Well, until I retired from full-time teaching in 2019, I was a professor of history at the University of North Florida, which is also in Jacksonville.
How long were you a professor of history at the University of North Florida?
Since 1988.
Have you won any teaching awards, Dr. Courtwright?
I have. I've won 5 teaching awards at the university.
What is your focus as a historian?
Well, I teach courses in medical history, American history, world history. I guess I should use the past tense because, as I say, I retired from full-time teaching in 2019.
What is your focus, Dr. Courtwright?
Well, in terms of my research, the thing I'm best known for is my work on the history of drug use and drug policy.
Have you focused on any specific drug more than others?
Yes, especially early in my career, I concentrated on the history of opiates in the United States.
How long has drug use been your focus as a professor?
Oh gosh, since I was in graduate school in the mid-1970s, even before I was a professor.
Did you write a thesis for your PhD?
I did.
What was that on?
That was on the history of opiate addiction in the United States up to the Civil War. I'm sorry, I misspoke, up to World War II. So it was basically the 1800s and then the 1900s up to World War II.
Why did you write your thesis on drug use?
Well, back in the 1970s, the country had just gone through a major heroin addiction epidemic. President Nixon had declared his war on drugs. There was a lot of ferment in the field. I mean, there were new treatment programs, methadone, therapeutic communities. That was the era of the Controlled Substances Act, a lot of concern. And I was just a young man in graduate school, and I asked the question, how did we get into this predicament? I mean, where did all of this come from? Why are some drugs illegal and others not? And I became curious about the history of this, and I wrote a seminar paper, and that led to a dissertation, and that led, I guess, to me being here today.
Have you written any books on the history of drug use, Dr. Courtwright?
I have, yes.
What are some of those books?
You'll see 2 of them. One of them is called Dark Paradise, and that was essentially a revised and expanded version of my dissertation, which was published by Harvard Press back in 1982. And then that was reissued in 2001. So remember I told you that the first pass went up to World War II, and then when I reissued the book in 2001, I took the story of opiate addiction in the United States down to the mid-1990s and then published that in 2001. And I was also lucky, really, to be able to identify a fairly large group of drug addicts who had managed to survive. These were people who had been addicted in the 1910s and 1920s, and they'd managed to survive 50 or 60 or more years as drug addicts, and most of them had ended up in methadone programs. And I recorded their life histories and used that as the basis for a second book, which I called Addicts Who Survived. So that's an oral history of narcotic addiction in the United States in the early to mid 20th century.
Dr. Corey, are you also a medical historian?
Yes, I'm a member of the American Association for the History of Medicine. I have served on the editorial board of its journal and on committees of the organization. I've taught the history of medicine and disease.
Can you explain to the jury what a medical historian is?
Well, a medical historian is someone who is concerned with the history of the medical profession and also allied health professions like pharmacy. In my case, I was also interested in the history of disease, or what is sometimes called historical epidemiology. So I usually taught the course as a twofer. I would talk about the history of medicine, and I would also introduce students at UNF to the history of disease and why patterns of disease have changed over time.
Have you published any papers in medical journals?
I have, yes.
What are some of those papers, Dr. Corey?
Oh, well, you'll see a few of them listed here. I was asked, for example, by the New England Journal of Medicine to publish an overview of American drug policy since the Harrison Act, which you'll hear about a little bit later today. And I've published on the prescription opioid epidemic and the heroin crisis. I've published on addiction and neuroscience. I've published on the history of the Controlled Substances Act back in 2004. So those are some of the topics I've written about.
You mentioned the New England Journal of Medicine. What is that?
That is a leading medical journal.
Have you taught medical history, Dr. Corey?
I have, yes.
Where
I've taught it both to medical students when I was at the University of Hartford before I came down here to Florida. I had a joint appointment with the University of Hartford and the University of Connecticut Health Center. So I taught history of medicine to medical students as well as to regular undergraduate students in Connecticut and then down here in Florida.
Are you also a historian of pharmacy and pharmaceuticals?
Yes.
What is a historian of pharmacy?
Well, an historian of pharmacy is someone who studies the history and the evolution of the pharmaceutical profession, although in the recent past, the field has expanded to look at the pharmaceutical industry and pharmaceutical products and pharmaceutical marketing and things of that nature. And in fact, recently they changed the title of the leading journal in the field, so it's now called The History of Pharmacy and Pharmaceuticals. And I'm also on the editorial board of that journal.
What do you do as a member of the editorial board for the Journal of the History of Pharmacy and Pharmaceuticals?
end up reviewing a lot of articles. One of the chores that you're assigned if you're on these editorial boards is you're asked to referee or review articles that are submitted, and you judge their quality and you make criticisms and suggestions and things of that nature.
Have you received any professional awards, Dr. Corey?
Yes, I have.
What are those?
Well, you may have noticed on that earlier slide I published a book called Forces of Habit, and the College on Problems of Drug Dependence gave that book its Media Award for 2002. It was published in 2001, and I received the award the following year. The journal Addiction, which is a leading international journal in the field of addiction studies, voted it the best book of the year. Although I guess I should tell you that book is not just about opiates, that's about drugs generally, the history of drugs and drug commerce in global history.
Dr. Corey, for those non-historians among us, how do you conduct historical research?
Well, you're testing hypotheses. You can't run a scientific experiment, set up the apparatus and run a trial in a laboratory and see what the results are and measure them against your predictions. But what you can do is you can generate ideas about what happened, and what you're constantly doing is testing those against the evidence. So you're looking for all different kinds of evidence to see if you can find a pattern, a coherent pattern that explains what happened in the past. And some of the kinds of evidence that I've looked at, or that really any medical historian would look at, would be things like data. So when I was writing my dissertation, I looked at opium import statistics into the United States that were collected by the government. I looked at government reports, congressional hearings, laws, statutes, Supreme Court decisions. I looked at archival material, marketing material in pharmaceutical and historical archives. I would look at case histories that had been recorded by physicians that were in hospital archives. I would look at all of the primary sources I could. And then when I exhausted the primary sources, one of the other things that you have to do is you have to look at what we call secondary sources. That's what other scholars have written about the subject. So you want to inform yourself as to what other viewpoints are, and then that's not enough. You can't just base your own research findings on what other people have had to say. You go back wherever you can to the original sources and test your ideas against them and test the ideas of other historians against them as well.
Dr. Corey, why are you here today?
Oh, I'm here to give you all an overview of the history of drug use and drug policy in this country, especially with respect to opiates. And I'm also here to tell you about the history of opiate addiction epidemics that have occurred in American history.
What historical research did you conduct for that testimony?
Well, gosh, it really started back in the 1970s. I mean, a lot of opinions are based on research that I did many decades ago when I was writing my dissertation and writing Dark Paradise and Addicts Who Survived. And then I have done additional research since I became an expert consultant for the plaintiffs back in 2018. I've done additional research that kind of extended that original research project.
Were any of the documents you reviewed about Walgreens, Dr. Corey?
Yes,
Did you reach any opinions as a result of your research?
I did.
Did you prepare a slide summarizing those opinions?
I did.
Dr. Corey, is this slide a summary of your opinions?
It is.
Can you please describe those opinions for the jury?
Well, you know, the basic thing I'd like to get across this afternoon is we've been here before. We had a very significant epidemic of medical opiate addiction in the late 1800s. And it was bad, and it generated a lot of concern both in medical circles and also in the general public. And there was a pushback against this. There was alarm that overprescribing had led to widespread addiction in the United States. And if you take a look at the second point, you'll see that the result of that pushback is that not only physicians, but the general public and legislators and regulators became more conservative in their attitudes toward prescribing opiates for pain. And that was the prevailing attitude or the conventional wisdom for most of the 1900s. And I have a kind of shorthand expression that I use to sum up that change. I call that narcotic conservatism. And so I say that basically the medical profession became conservative with respect to prescribing these drugs in cases of chronic pain. And then finally, unfortunately, we've had a second medical opiate addiction epidemic, and that commenced in the late 1990s, and that was due to the fact that we, or not only doctors, but general public as well to some extent, had changed its mind about appropriate use of opiates, and there was a significant increase in prescribing of opiates for cases of chronic non-cancer pain. And I regard that as one of the principal causes of the second big medical opioid addiction epidemic in American history. And you'll notice I use the word opioid. Back in the 1800s and for most of the 20th century, these drugs were called opiates. And since the 1980s and 1990s, because there's so many synthetic equivalents of these drugs, they're now generally referred to as opioids. But just to be clear, we're talking about basically the same category of drugs.
Dr. Corey, I want to ask you about some of the words under your third opinion. You use the words undermined by misinformation and by ignoring or distorting the past. Can you explain what you meant by those words?
Yes, I mean, there was a great deal of evidence that had accumulated that basically backed up the conventional wisdom about the dangers of prescribing these drugs. And there was a certain financial interest. We know this because the pharmaceutical industry in the mid-20th century had previously attempted to crack the non-cancer pain market. There's a big market out there, but if it would be possible at all to get access to this market, you were going to have to overcome these conservative ideas about when it was appropriate to use these drugs.
Do you have a shorthand term you use to refer to this?
I do. It's opioid revisionism or just revisionism. And again, just so I don't have to keep saying, there were advocates for the more liberal prescribing of opiates in chronic non-cancer pain, which is it's a lot of words. I just boil that down to the word revisionism.
Dr. Horry, have you researched whether Walgreens was involved in opioid revisionism?
I have.
What did you conclude?
I concluded that it was.
Dr. Horry, I want to turn to the first opinion you have there. What was the first medical opioid epidemic?
Well, there have always been some cases of medical opiate addiction in the United States in the 1800s, but there was a big increase in the last third of what we call the 19th century. So in the late 1800s, starting around 1870, there's a sharp rise in the number of new cases of opiate addiction, and there's also a sustained rise in the per capita or the per person consumption of medical opiates in the United States.
When did this epidemic occur, Dr. Portwright?
Well, it really takes off around 1870. That's when the rise is especially rapid.
How many people became addicted in this epidemic?
Well, in my research, I concluded that at its peak, which was in the mid-1890s, there were probably around 300,000 opiate addicts, but of those, around 200,000 were addicted to medicinal opiates, mainly opium and especially morphine.
Can you give a sense of the magnitude of that epidemic in terms of the population of the country at that time?
I can, and this is a ceiling estimate, a maximum figure, but by the middle of the 1890s, there were at most around 4.5 per thousand Americans who were addicted to any form of opium, and by around 1920, early 1920s, that percentage or that rate had fallen to about 2 per thousand.
Did you listen to the opening statements, Dr. Corwright?
I did.
Was there anything that surprised you in those opening statements?
Yes.
What was that?
Well, one of the things that really stood out was the statistic. I think you heard it as 1 in 50, that 1 in 50 Floridians was addicted. And if you do the math, you know, that works out to 2 per 100. And in the 100 years before, in the early 1920s, it was 2 per 1,000, and now it's 2 per 100. And I was just struck by the magnitude of the change. So I guess another simpler way to say that is that the second medical opiate addiction or opioid addiction epidemic was even worse than the first.
How did approximately 200,000 people become addicted to opiates in the late 1800s?
Well, the single most important cause was that doctors got a hold of hypodermic syringes in the 1870s. So this is kind of interesting, the history of this. It's first introduced in the country in the 1850s, but it's a gadget. You know, not a lot of people were using it. But by the 1870s, everybody was using it. And number one reason for using a needle and syringe is to inject morphine into patients. And that was, it did produce speedy relief. And, you know, the patients felt great, at least for a time. And so it was almost like doctors had a magic wand. And when they were dealing with patients with painful symptoms, they could at least temporarily, in fact rather dramatically, alleviate those symptoms. And so they were tempted to overuse it, and they did. And a lot of people ended up being addicted to morphine.
What types of pain conditions were opiates typically used for in medical practice at that time?
unfortunately, just about any kind of painful condition. Now, there were some other indications, and when you all hear the word indication, that means what is it you should use a drug for, basically. But people would take these drugs for other things. Opiates have constipating properties. When people had diarrheal diseases like dysentery, often they would take something like laudanum or paregoric, which had opium in it, to combat the diarrhea. But the single most important source of medical addiction was using morphine to treat somebody who had a disease that was causing chronic pain. And that could be anything. It could be neuralgia, it could be joint problem, arthritis, rheumatism, back pains.
In the late 1800s, how could a person obtain morphine?
Very easily. You didn't necessarily have to get it from the doctor. You could, in some cases, you could even get it from a mail-order catalog. You could purchase opiates, or you could walk into the drugstore. And we know that it wasn't only doctors who were responsible. There were some cases of addiction and overdose deaths that were caused by people having these opiates as home remedies, and they would get into trouble that way. But we also know from several surveys in the late 1800s that the most common route to addiction was to be introduced to these drugs by a physician.
Were there any legal restrictions on the supply of morphine in the 1800s?
Very few. I mean, there were some laws that required the pharmacist to write into a poison registry that you had purchased morphine. It is toxic, and there were concerns about the use of these drugs, possibly in criminal activity. But in terms of, I'm sick, my baby's sick, somebody in my family is sick, I need some laudanum, it was very easy to get these drugs.
So who was affected by this epidemic, Dr. Corey?
Oh, interestingly, mainly women. So we know that because a lot of this is originated by doctors, it's mainly people who go to doctors who are most at risk of becoming addicts. And in the 19th century, that was disproportionately women. So, there's this attitude, I guess it's still true today, but there was this attitude that men are supposed to sort of grin and bear it and put up with the pain, and you don't go to the doctor. But women were more likely to seek medical advice. And of course, women also had cramps, premenstrual cramps, which back in the 19th century was called dysmenorrhea. So they would seek medical advice and medical treatments for that as well. And so it's mainly women, but it's not necessarily women in any particular social class. This is something that happens, it's pretty widespread throughout society because, after all, anybody can become sick, or anybody can have cramps or neuralgia or whatever.
What was the effect of addiction on those who became addicted?
Oh, it was often devastating. It was ruinous for them and their families. It's very clear from both the popular press and the medical literature that the families also suffered terribly, but the individuals not only became addicted, but in many cases they developed infections from using contaminated needles. In the case of women, they sometimes gave birth. Of course, they always, if they were addicted to opiates, they always gave birth to infants who were also opiate dependent, and that received a lot of attention in the medical literature. There was concern about changes in moral character. One of the other things that you see noted, again, both in the popular and the medical literature, is that addicts were liars. They would conceal their condition. They were devious. They became sneaky. They became remote. There was a lot of concern over the moral changes that the use of these drugs brought, as well as the physical harms.
A little bit of a test for you, Dr. Corey. Who is H.H. Kane?
Oh, H.H. Kane was a well-known addiction specialist. He was a physician, an MD, who wrote several books and articles about opiate addiction in the late 1800s.
Did you rely on anything H.H. Kane wrote in your research for this case?
I did, not only in the research for this case, but I think I was using Dr. Kane all the way back in the 1970s.
Dr. Corey, is this a passage from a book from H.H. Kane?
It is, yes.
And when was this book published, Dr. Corey?
This book, Drugs and Enslaved, was published back in 1881.
Why did you include this excerpt in your slides?
Well, you remember earlier I said there was pushback against this liberal use of opiates, especially the hypodermic administration of morphine. I think that this book is a classic example of that pushback, of that criticism originating within the medical community about the dangers of these drugs. And that's why it's a good source. I mean, it boils down a lot of what other people were saying in fairly succinct form.
Dr. Corey, does this say anything about how physicians used morphine at the time?
Yes, I mean, and not only in this passage, but in several other passages in the book, it talks about doctors introducing patients to this form of opiate use, and then the patients continue, and then, I'll just paraphrase this, they go on and they become addicted, and he notes in this article that this happens to people in all walks of life. And then he uses a word which is really common in the literature of the 1800s. He says they become enslaved. It's like they have shackles. This is probably the single most common metaphor for addiction in the 1800s. These people are enslaved, and they come to hate their enslavement. They loathe the condition that they find themselves in. And it's not simply that they become enslaved to the pleasurable effects of the opiates, but the reason they can't break free from this is if they try to, and they often did. Of course, they experience withdrawal symptoms. And he goes on and he says, and you'll see it in the slide, he says they're sunk into a living hell. You know, this is the hook, this is the trap.
Did doctors continue to use opiates in the 1800s despite writings like this from H.H. Kane?
Unfortunately, yes.
Why did they do that?
Because there wasn't a whole lot that doctors could do for you in the last third of the 19th century, in the late 1800s. So here's the situation. People like Dr. Kane are warning them, this is dangerous, this is a bad idea, don't overuse this unless you're talking about something like terminal cancer pain. But on the other hand, there aren't a lot of cures in medicine, and there are a lot of sick patients who are looking for help, and morphine does alleviate pain, no question about it. So there's still this temptation to overuse. It's kind of like, you excuse the cliche, but it's kind of like turning the battleship. You know, it takes a long time for these warnings to sink in, and one of the main reasons for that is that there wasn't a lot else really that doctors could do, and at least initially they didn't have a lot of substitutes for opiates, although that situation did improve in the course of the last part of the 19th century.
What drugs were introduced that improved that situation for the options available?
Oh, well, in the 1880s, you start to get new drugs like phenacetin, which is like a fever fighter and an analgesic. There were some new drugs that became commercially available as painkillers.
Dr. Corey, did the first medical opioid epidemic end?
You know, it would really be more accurate to say it petered out. We know that the per person consumption of opiates tripled between 1870 and 1890. And we know that it continued to increase in the early 1890s. And then finally the battleship turned, and that per capita consumption started to come down, even before the end of the 19th century, even before the year 1900, it starts to come down, and it continues to come down in the first 2 decades of the 20th century.
Why did that battleship begin to turn, Dr. Corey?
Well, with respect to medicinal opiate addiction, it's because a lot of these very ill and older medical addicts were dying off. They were either dying off or they were quitting in some cases, and they weren't being replaced by new addicts. So the message of narcotic conservatism did sink in to the medical profession. Gradually over time, they'd gotten the message by the end of the 1800s and beginning of the 1900s. They understood, and they were creating fewer new medical addicts. So as the old ones die off and you have fewer new ones created, the result is that the overall prevalence, the number of addicts, starts to come down, and the rate also starts to come down.
Dr. Corey, your slide uses the term lessons learned. What lessons were learned?
All the lessons I've been describing, that you want to use these drugs sparingly. Look, doctors understood that opiates were really valuable medications. In certain cases, they were indispensable. When you're treating terminal illness, a disease like cancer, advanced cancer, cases of surgery, shock, trauma, there's certain circumstances in which these drugs are appropriate. But when I talk about narcotic conservatism, I think the essence of it is don't use these drugs indiscriminately to treat pain, especially chronic pain, because if the person keeps coming back and seeking to use the opiate because the painful symptom has returned, they're going to get addicted.
Who learned those lessons?
Well, I would say that it was not only the medical profession, but I would say the pharmaceutical profession, I would say the general public. I would say that this was something that was certainly on the mind of regulators and legislators as well. In Europe now, we're in the 1900s, but they're starting to learn the lesson in the late 1800s, and it carries over into the 1900s.
Were these lessons reflected in the medical literature, Dr. Corey?
Oh, yes.
Dr. Corey, what is shown on this slide?
This is an article which appeared in the Boston Medical and Surgical Journal. That's what they used to call the New England Journal of Medicine. Later on, they changed the name. And this is an article by a Dr. James F.A. Adams, which appeared in 1889.
Why did you include this excerpt in your slides?
Well, this speaks to a point I was telling you all about earlier. When I was talking about substitutes. So what you have here is an article that is devoted to this very question, substitutes for opiates in cases of pain. And he's a very strong advocate for using them whenever you can, because there are certain intrinsic problems with opiates.
Was this medical journal reflective of narcotic conservatism, in your opinion?
Oh yes, I mean, one of the things you do as a writer and as an historian is you look for sources that really, go to the nub of the matter, that reflect the thinking of a group of individuals and express that thinking very clearly. Plus, this particular article happened to appear in a very prestigious medical journal. This is the kind of thing that would have been widely read at the time. So that's one of the reasons I cited it, yeah.
What parts about this are reflective of narcotic conservatism?
Well, he reiterates the reasons why you need to be wary of using these drugs. Number one, they're toxic, okay? Number two, they have side effects, and side effects are everything from constipation to mood alteration to depressed respiration, which you also heard about in the opening this morning. And then number three is what he calls the opium habit. And the opium habit is the way that people in the 1800s referred to what we call addiction or opioid use disorder. He said he thinks that by 1889 there are already about 150,000 Americans who have developed the opium habit, and not even counting those who got into trouble by doing things like smoking opium, the non-medical cases.
How did this article compare to other historical sources available during this time period?
It corroborated them. Again, I mean, there are many, many articles of this nature, And I just picked this one because it's a very clear expression of what doctors were worried about and why they wished they had other drugs instead of these opiates, which even though they were potent painkillers, did carry these risks with them.
Did this article suggest any alternatives to opioids?
It did. I mean, it called attention to the kinds of drugs I was talking about earlier, which were just then starting to become available.
How did the typical medical uses for opioids evolve after 1900?
How did it evolve after 1900? Well, as I think I remarked earlier, doctors changed their prescribing habits. Or no, let me take that back. Most doctors changed their prescribing habits. So the younger, better educated, more reform-minded physicians became more conservative about prescribing drugs. It's clear that there were still older doctors who were trained at a time when the dangers of narcotics were not stressed so much. They were still prescribing or over-prescribing opiates. And however, it's interesting to me as a medical historian that becomes a mark of a second-class doctor if by, say, 1910 or 1920, you're just saying, oh, whatever you got, go home, here's a prescription, take an eighth of a grain or a quarter grain of morphine. It's a sign you're a bad doctor. You're just blindly treating the symptoms of a disease that might be otherwise diagnosable or treatable. And so that was maybe more of an answer than you needed, but I would say that the best doctors were becoming increasingly wary of this older pattern of liberal prescribing for all kinds of painful conditions.
Let's fast forward a couple decades. What did medical textbooks begin to teach about opioids in the 1950s?
Oh, the same thing, but in spades, so to speak. I mean, they made it even clearer that this was something that you really needed to be careful about. This wasn't just an idea that went away after the 1920s. Okay, problem solved. We got over this first epidemic. Now we don't have anything to worry about. No, the medical literature continues to emphasize the dangers of these substances.
Was there any medical textbook that was reflective of this education?
Well, there were several, but one in particular has often been mentioned by medical historians, not just me, but by other historians as well. And that's Goodman and Gilman's Pharmacological Basis of Therapeutics.
Is that the book shown on this slide, Dr. Corey?
It is, yes.
How was this book used in medical schools?
Well, it became a standard text. It was not just about narcotics. This is about the proper use of all sorts of different classes of drugs, but it did have a chapter on narcotic drugs.
What was relevant about this book to your historical research?
It showed how the lesson of narcotic conservatism had stuck, and it was being taught to new generations of medical students. And this, by the way, was a great medical bestseller. This book it went through any number of editions. This was widely adopted in American medical schools.
This one of the highlighted passages uses the term narcotic. What does that refer to in this context?
When a doctor talks about narcotics in this context, they're talking about opiates, basically.
Dr. Corey, until the 1990s, what was the prevailing view for the proper medical uses of opioids?
The view that you just saw here in this slide, namely that you don't use them if you don't have to use them. That's number one. If you do, if you do use a narcotic, you want to use the minimal amount for the shortest possible period of time. And look, the other thing you want to do is you want to make sure the patient doesn't become addicted. You want to follow up. You want to have that patient come back, especially if you, for whatever reason, think it's necessary to give an extended course of treatment with these drugs. They even say that don't even tell the patient that they're receiving an opiate in the first place. Just say, I'm going to give you something for the pain. And above all, don't instruct the patient in how to self-administer these drugs hypodermically. That's really dangerous. But you can avoid all of this rigmarole if you can give the patient something else in the first place. If another drug is suitable, will accomplish the same end, don't employ a narcotic drug.
Until the 1990s, what was the prevailing view for using opioids for low back pain?
Oh, the same. That would have been one of the conditions that you don't ordinarily resort. You don't ordinarily prescribe an opiate if you can possibly avoid it.
Dr. Corey, I want to switch to public attitudes for opioids. How did public attitudes toward medical opiates change from the 1800s to the 1900s?
They went in the same direction. I would say that the American public became increasingly wary of these drugs, and not just because of the potential for addiction, but also because of fear of poisoning. One of the things you need to remember is it wasn't just pain patients that took these drugs, but sometimes people would give laudanum or paregoric to babies who were experiencing colic or teething or having trouble sleeping, and there were cases of infants who were dying of overdoses. And so there was a lot of concern about the toxicity of these drugs.
You mentioned aspirin earlier, I believe. What was the significance of that being introduced?
Oh, okay, so go back to that article that I showed you all earlier, Dr. Adams saying that there are substitutes available for opiates in pain cases. Those substitutes continued to become available, and the most famous example is aspirin. Aspirin was introduced commercially in the United States in 1899. Initially, it was a prescription drug, but it became, in a relatively short period of time, it became available as an over-the-counter drug. And it was, in the eyes of both physicians and the general public, it was a very good substitute for opiates.
Dr. Wright, what is shown on this slide right there?
Well, this is an ad I picked out of a Florida newspaper. They ran these ads all over the country, but this one in particular comes from the Miami Herald, and this is from the early 1920s. And the thing that really jumps out to me as a medical historian is the list of recommendations. You know, what do you take this drug for? And you can see that blown up on the side in the box. And you take it, colds, headache, toothache, lumbago, that's back pain, earache, rheumatism, and so on. And then in the end, it just says, you see where it says pain, just pain in general. And it's like you look at this as a medical historian and you think, gosh, that's what they gave opiates for in the 1800s. And now, here's something else, which the doctor can recommend to you, or which you yourself can take, because you got a bottle of aspirin in the medicine cabinet at home.
I want to switch topics to the laws that applied to opioids, Dr. Corey. Prior to 1900, what laws applied to prescribing opioids by doctors and dispensing opioids by pharmacists?
Prior to the 1900s, very few. I think I mentioned earlier that sometimes you had to, make a record of a sale, but that was about it. There wasn't much in the way of what we would call a prescription law, where you had to have a doctor's prescription for the opiate.
Were any laws enacted after 1900 that applied to prescribing and dispensing opioids?
Yes.
Did you prepare a slide showing some of these laws?
I did.
Dr. Corey, let's start on the left. What was the Pure Food and Drug Act of 1906?
That was a famous federal law that required the labeling of certain ingredients on patent medicines, or in fact any medicine that contained these ingredients like alcohol or opium or cocaine. One of the things I haven't really told you about yet this afternoon is that another way people could get hooked in the 1800s is they would buy these things called patent medicines. And this was like, I guess you'd call it snake oil or something like that, but it was Dr. So-and-so's cure for thus and such. And you didn't know what was in it. And sometimes the ingredients were potentially addictive drugs. And the federal government, first the federal government, and then our government in Florida in the following year, 1907, said you have to list these ingredients on the label. And when that happened, the sales of these products dropped 20 to 30% within a couple of years, because people have been reading about the dangers of these drugs, and they go into the drugstore and they pick it up and they look at the label. My gosh, this has got morphine sulfate in it. I don't want to take this.
What was the 1909 Florida prescription law?
Oh, that said, if you want, for anything other than a so-called exempt preparation, which is something like cough syrup that just has a minuscule amount of a narcotic in it. But if you want to get anything stronger, you have got to have a doctor's prescription when you go into that drugstore. And not only that, the druggist cannot refill that prescription. You have to go back to the doctor and you have to get another prescription before that druggist can legally refill it.
Let's fast forward a couple years. Harrison Act of 1914. What's that?
Yeah, that's the beginning of what is often referred to as the closed system of narcotic control. And that's another phrase that you're going to hear a lot of, I would predict, during this trial. And this is when the federal government first really starts to put into place a system that will guarantee that all narcotic transactions are transparent. Everybody knows who's selling what to whom, who's taking what, and that those transactions will occur within legitimate medical channels.
What is diversion, Dr. Corey?
Well, a simple definition of diversion would be use outside of those legitimate medical channels, as defined by law. I mean, what the law does is basically it says, look, if you handle narcotics in any way, shape, or form, if you're a manufacturer, an importer, a pharmacist, a doctor who writes these prescriptions, you've got to register with the government and you've got to pay a small tax and you've got to keep accurate records. And any sales or transactions outside that system of registrants, that's illegal. That's a crime. You are subject to fines or imprisonment if you're not registered. But there's one crucial exception. And that exception is if you're just an ordinary patient and you have got a prescription that was written by a state licensed physician or dentist or vet, it's a legitimate prescription, then you can possess the narcotic drug. That's okay. That's basically what we mean by a closed system.
Dr. Corey, what is Webb et al. Versus United States?
Well, okay, so the law didn't really clarify what was meant by a legitimate prescription, and so lawyers do what lawyers do, and they fought about this. That led ultimately to the Supreme Court ruling that in certain circumstances, doctors and pharmacists were guilty of conspiring to violate the Harrison Act if the sales were so large and so clearly designed merely to support people in a drug habit that constituted a violation of the Harrison Act.
Who was the et al. In that case?
Oh, it was a pharmacist. So this Webb guy, he is a physician, and he's in cahoots with a pharmacist named Jacob Goldbaum. So basically, people walk into Dr. Webb's office, and for 50 cents, he'll write him a prescription for morphine tablets. They go off to Mr. Goldbaum, who fills the prescription, and he's bought out the wholesaler, and he's got lots and lots of morphine tablets, and he sells you these drugs, and he's selling huge volumes of these pills. And the question is this a legitimate prescription within the meaning of the Harrison Act? That's the basic question. And the Supreme Court said, no, it's not.
What happened to Mr. Goldbaum?
Oh, well, he was convicted of conspiracy to violate the Harrison Narcotic Act, and his conviction was upheld by the Supreme Court of the United States.
What is direct sales versus United States?
Okay, so this was another case that involves another aspect of the same issue. So Direct Sales was a company in Buffalo, New York, which sold morphine tablets through the mail. They don't have sales reps or anything like that. They just send out these mail-order catalogs, and you can say, I want not only morphine, but there are other drugs you can buy from this company. And people who ran this company had registered with the Harrison Act. There was a man named George Dotterweich, who was the president of this company. He kept records, he paid his tax, filled out all the paperwork, but he was selling to people he had never met in small towns. He was selling inordinately large quantities of morphine tablets, and he was warned by the Bureau of Narcotics, which was the federal agency that was responsible for enforcing this law. He said, they told him to stop, and his position was no. If I can sell what I want to sell, and then if these doctors or their patients are diverting these drugs, that's your job is to stop them. I can just sell quantities however large I want. The district court, the circuit court, and the Supreme Court of the United States said no. You knew that by selling morphine tablets in these quantities to small town doctors and communities of a few hundred or a few thousand people, that these drugs were going to end up being diverted into the black market and supporting addicts' habits.
Dr. Corey, I asked you earlier about opening statements. Was there anything in the opening statements that you heard relevant to direct sales?
Oh, yeah. So this question of quantity is actually an old issue. As an historian, yes. I mean, that becomes, later on, it becomes one of the issues about did Walgreens know or should it have suspected that selling large quantities of pills in communities like Hudson, that was what we would today call a red flag. This, in fact, is a very old issue.
Finally, Dr. Corey, Controlled Substances Act, what was that?
Well, this is basically an attempt to tidy up the control system that had been, at this point, evolving since the early 1900s. By 1970, Congress had passed 50 laws and amendments that dealt with narcotic drugs in this country. And sometimes state laws were dissimilar. And another problem was it's not just narcotics anymore. There are other drugs like amphetamine or sedatives or tranquilizers, and we need better control of these substances as well. And so this was, you heard the word schedules this morning, I think, in the opening statement. This is the drug that creates the modern scheduling system back in 1970.
Were there any new obligations imposed by the Controlled Substances Act?
There were, yes.
What were those?
Well, so this imposes on the registrants certain responsibilities. First, by registrants, you need to understand that under this law, there were two categories of registrants. There are about 500,000 people who are ordinary registrants, doctors, pharmacists, and so on, and they have, under the law, the responsibility to prevent theft and diversion. But there's a second category of registrants called non-practitioner registrants. Now, those are people like the manufacturers and the distributors and the big pharmacy chains. So they're in the business of making and shipping the drugs. They have additional responsibilities. In effect, the law deputizes them.
Judge, can I interpose an objection? We have a historian testifying about the content of current law at this point. It's a problem for two reasons.
All right. We need to do it at bar, or can I argue from there?
No, I'd like the judge to instruct the witness to cease testifying about the content of the current law and to ask counsel to move to a different topic.
Your Honor, I can move to a different topic. I want to move to pharmacists. This case is about pharmacists, Dr. Corey. How did pharmacy practice for opiates change from the 1800s to the 1900s?
Well, I would say it also became more conservative. So earlier I was telling you about how there's growing concern in the ranks of the medical profession about the overuse of these drugs. Something very similar happens in the pharmaceutical profession. The better educated, the more reform-minded pharmacists are saying, look, we've got a problem. We need better control of sales of these dangerous drugs. And they generally supported things like Florida's prescription law. So that's certainly one of the things that happens. And then the other thing that happens, you already figured this out from what I told you about the Harrison Act. The pharmaceutical profession itself comes under tighter control. It's subject to both state law and federal law in terms of the dispensing of narcotics.
How did those laws change pharmacy practice from a historical perspective?
Well, I mean, it made it more difficult for somebody just to walk into a drugstore and acquire an opiate.
What is the Federal Bureau of Narcotics, Dr. Courtwright?
Oh, that was from 1930 on, that was the name of the lead enforcement agency for basically supervising or safeguarding the system of narcotic control. It's the predecessor of what we today call the DEA.
What effect, if any, did the Federal Bureau of Narcotics have on pharmacists?
It reinforced this internal reform movement by reminding pharmacists that they too had a responsibility to make sure that illegitimate prescriptions, what they would have called illegitimate prescriptions for narcotic drugs, were not filled.
Did you prepare a slide of what pharmacists were reminded of?
Oh, I did, yes.
Dr. Courtwright, what is shown on this slide?
Well, it's a pamphlet from the Bureau of Narcotics. I believe the date of this is 1938, and it's essentially saying that pharmacists have a corresponding responsibility, and that they are, they have to make sure that the prescription has been issued in the course of professional practice. That this is an appropriate prescription. They are another line of defense. They're like the last line of defense. Having a prescription itself does not suffice. It also has to pass muster with the pharmacist.
Dr. Courtwright, in your opinion of the history of pharmacy practice, how long have pharmacists understood this corresponding responsibility to exist?
Oh, even before this pamphlet. I mean, they knew that this was the case from the state laws that had been passed earlier, from the reform movement within the ranks of their own profession, and also from pharmaceutical training. I mean, this is something that's emphasized in pharmaceutical school by the 30s, 40s, and 50s.
Are you familiar with the term red flags?
Yes, I'm familiar with that term.
What does that mean in pharmacy practice?
Well, in the context of this case, that would be something that would make you suspicious about the prescription.
Was that term used by pharmacists in the mid-1900s?
No, I didn't see that particular phrase, at least in the sources that I examined. They used other language like, this is not a legitimate prescription, or this is not something that would typically be written in the course of ordinary medical practice. But it's clear that's what they're referring to.
What were pharmacists trained to do with respect to red flags in the 1900s?
Well, there are several things they could do. I mean, the most obvious thing is call the doctor. When in doubt, are you sure you really meant to write this prescription? Did you write this prescription? Because another thing that they're trained to look out for is forgery or alteration. So some doctor may have written a prescription for 10 tablets, and then somebody else sneaks in a 0, so it's now 100 tablets. So they're trained to check, and then if in doubt, they shouldn't fill it. Or in some cases, they are unable to reach the doctor. They might just do a partial fill of the prescription rather than filling the whole prescription.
Dr. Hoyt, for opioids specifically, have you done any research what pharmacists' attitudes toward opioids have been in the 1900s?
In the 1900s? Mm-hmm. Yes.
Dr. Courtwright, what is shown on this slide?
This is an excerpt from a study that was done in 1999. This is an article that's by Drs. Greenwald and Narcessian. I don't know if you can make that out on the slide, but those are their names. And this was a study of community pharmacists.
Dr. Courtwright, there's a passage that's highlighted. Why did you highlight that?
Well, So you need to know a little bit about Drs. Greenwald and Narcessian. They were revisionists. They were people who advocated for more liberal opioid prescribing, and that they were worried that pharmacists were a potential obstacle to this. And not just because the pharmacist, him or herself, might refuse to fill the prescription or question the prescription, but they understood that pharmacists are also advocates, that they provide advice to people, and they, among the people they advise with respect to new trends in medications are patients, which is what you see in the highlighted passage here.
How would a pharmacist be a potential obstacle to more liberal opioid prescribing?
Potentially by refusing to fill the prescription. I mean, that's the most obvious case, or saying something to the patient, Mrs. Murphy, do you understand that this is a narcotic drug or something of that nature? The possibility they might frighten the patient.
Dr. Corey, there's a table of some figures underneath that. Why did you include that in your slide?
Because it shows that these attitudes lingered. Okay, so this is another case of maybe the battleship turning around slowly. So this survey was based on people who had been trained, pharmacists who had been trained between 1960 and 1995. And so they asked them a series of questions. I know you all have taken surveys like this, 1, 2, 3, 4, 5. They give different possible answers. Is it appropriate and legal to prescribe opiates under these circumstances? For example, Jeff, could we take a look at row C, where it says chronic non-malignant pain only? So, so the question is asked to these pharmacists is, if somebody shows up and they have a prescription for an opiate for long term, you know this person has been taking this drug for an extended period of time, several months it says, and you know that they're not a cancer patient. First question, is it lawful and generally acceptable medical practice? Well, 1 out of 6 said yes, that's fine, that's lawful, that's acceptable. But then as you go across this row, you see that the pharmacists express varying degrees of concern. Some say, well, yeah, it's legal, but it probably should be discouraged. And then others will say, well, maybe this should be investigated. And others say that it's just out and out unlawful. And then finally, there's a surprisingly large category. You see that very last, Jeff, could you go over to where it says 38.9% in that row? When you take a survey, there's usually I don't know, or I have no opinion box in the survey. Okay, so there were some of them who just were uncertain, which was interesting to me as a medical historian, because I also know from my research that attitudes towards the appropriate use of these drugs were in a state of flux during this time period.
Dr. Corey, I want to break that down a little bit. On the row C, chronic non-malignant pain, can you explain to the jury what that means?
Oh, right. So I think one of the things I mentioned earlier is that in the 1800s and in the 1900s, it's understood that if a person's dying of a disease like advanced tuberculosis or cancer, it's entirely appropriate to use these drugs. But the key phrase here is non-malignant. Non-malignant is just a word that means non-cancer pain. So these are not cancer patients. These are patients with bad joints or neuralgia or bad backs, something like that.
And looking at the second category, what would a pharmacist do in the second category, the 47.2% that thought it should be discouraged?
Well, one of the things that they might do is they might, as I mentioned earlier, they might warn the patient that this was a very powerful and potentially addictive substance.
Was that number, 47.2% of pharmacists that might warn patients, reflective of the other sources you saw about pharmacists' attitudes?
Yes.
Dr. Corey, as a history of pharmacy practice, what might a pharmacist do besides warning a patient when they were uncomfortable with an opioid prescription?
Blow the whistle.
What effect would these attitudes have had on the dispensing of opioids for chronic non-cancer pain in the late 1990s?
Objection, Your Honor, foundation.
He's a historian. He's studied pharmacy practice.
This is a very different question. It's a hypothetical question about causation.
Does he have basis for knowledge on that?
Dr. Corey, have you researched what the effect of these attitudes was on dispensing opioids?
Yes.
And what research did you do?
Well, I was looking at documents that were produced in this case.
And what documents did you find informative to this opinion?
I found several references to pharmacists refusing to fill prescriptions for Schedule II opioids. Those are the most potent legal opioids. Schedule I drugs, as you heard this morning, are things like heroin that are completely illegal, and drugs like oxycodone or hydrocodone are in this Schedule II, which means they have legitimate medical uses, but they also have a fairly high danger of abuse or addiction.
What effect would these attitudes have had on pharmacists dispensing opioids for chronic non-cancer pain in the late 1990s?
They might have killed the dispensing of the drug if the pharmacist refused to fill the prescription. I found evidence of that, but I also, there's another issue called compliance, which is a question of whether the patient actually takes the medication or takes all of the medication, and if the pharmacist was communicating to the patient that he or she felt that there were dangers with this medication, it might scare off the patient from taking all the pills.
Dr. Corey, by the 1990s, what knowledge was available to medical professionals about the risks of opioids?
Actually, I would say, and I did prepare this demonstrative, but by 1980 specifically, this is what anybody could find out, not just medical professionals, but basically anybody with a library card and an inclination to do a little research. This is what's available to you. So remember, this all started back in the 1800s, and there are hundreds, if not thousands, of case histories. Some of them have been brought together in the form of statistics. Others are described as individual case histories. These have appeared in medical journals. These are really well indexed. Some of these have even been reprinted. I mean, there was a lot of interest in this subject in the 1970s, as I said, and so some of these older studies were reprinted and they were anthologized. And then in addition to that, you have, well, do you remember Dr. Kane's book? Okay, Dr. Kane's book, Drugs That Enslave, was reissued as a reprint. It's still available in a Kindle edition to this day. People like me, professional historians, were starting to publish histories of America's first medical opiate addiction epidemic. You had medical texts like Goodman and Gilman. You had this whole system of the closed system of narcotic control that had evolved over time, had been strengthened, had been expanded to impose additional obligations. Oh, and then on top of that, the press has not forgotten about this story. I mean, that by then, by the 1970s and 80s, the focus was mainly on illicit drugs, but there's still many stories of addiction and overdose deaths and so on in the press. And then finally, there's something else. And now this was not really available earlier in the century, at least not to the same level or sophistication, but by the 1970s and 1980s, there's the discipline of epidemiology, which is basically the study of the distribution of diseases in human and animal populations. Epidemiologists had been using computers and statistics to examine questions like, why do some countries have higher rates of addiction to particular drugs than other countries? Good question. And it turns out that these studies were showing that the single most important factor when they looked at things like income and urbanization and all these other variables, but the most important factor was proximity to supply. So the greater the availability, and this was true not only of opiates, but of other psychoactive substances like alcohol, then the more you're going to have by way of addiction and drug-related illnesses like cancer and also death, that the mortality will also increase in proportion to the overall availability of these drugs in a given society. And these studies, by the way, were not just U.S. studies. They were often comparative studies looking at different nations.
Dr. Corey, after the first medical opiate epidemic in the late 1800s, did this country have another medical opioid epidemic until the late 1990s?
Yes. We didn't have one until the late 1990s. In the late 1990s, we did. But I'm sorry, I misunderstood your question. But no, we did not have another big wave of medicinal opiate addiction up to the very end of the century, up to the late 1990s.
Why not, Dr. Corey?
Because primary prevention worked. Because people who were not exposed to narcotics did not become addicted to them. Narcotic conservatism was like a dam or a barrier that prevented another flood of medical opiate addiction in the country.
Your Honor, I'd suggest we finish part 3 of the play tomorrow. We're almost at 5 p.m.
All right, so we are going to break for the day. I guess I wanted to see, is there anything the attorneys and I need to finish up with, talk about today after this?
There's a pending motion on one of the witnesses. I don't know if you want to hear that now or in the morning.
All right. I have a couple of issues I wanted to talk to a few of the jurors about, scheduling type issues, medical update type issues. That's something we need to do off camera. else do we need to do today?
Your Honor, we filed a motion regarding a witness, Ms. Lane. Schultz, we are prepared to address that. If you want to hear that now.
Okay. So I haven't read it and don't know anything about it because I've been working on the depositions, but I'm happy to hear about it if you guys can just break me today.
I believe she's potentially testifying tomorrow, so
So it's important to do today.
to address it with you today.
Okay. And am I caught up on enough deposition designations to get us through this week at least?
We're going to submit a short one tonight or tomorrow.
And should that mostly get us through this week?
I think so.
I did as many as I could this weekend, hoping that that would be enough to
We appreciate all your
through
efforts.
this week. And it'll be a short week. I forgot to tell them we're off Friday. Darn it, you even reminded me. All right, well, I'll have to make a note to tell them in the morning. Try to remind me of Friday. I do want to tell them as early as possible in case they have things to schedule. All right, are we ready to proceed with the motion?
Your Honor, thank you. May I use the podium?
Sure.
Thank you. And understanding of Alex Schultz on behalf of Walgreens, Your Honor, thank you for the time at the end of a long day. May I approach the bench, just giving Your Honor a copy of the relevant file? Thank you, Judge. Your Honor, on Friday afternoon, Walgreens filed a motion to exclude the testimony of an individual named Gail Lane, who the plaintiff indicated it may call for testimony live as early as tomorrow. Now, the reason we filed this motion, Judge, is because the way that the plaintiff intends to structure Ms. Lane's testimony in this case is incompatible with Florida law. And the plaintiff filed an opposition to our motion yesterday afternoon. There is nothing in that opposition from a Florida law perspective, no case, no statute, that allows them to do what they're attempting to do here, which is artificially restrict the scope of Ms. Lane's testimony by relying on the fact that she is a former employee of the Drug Enforcement Administration and thereby under federal law restricted as to the content of what she can testify to. So to give Your Honor a little bit of background on this issue and how it came up, and it was entirely avoidable, Judge, had the plaintiff been more forthright with his disclosures, and there is a solution to it that we would propose to Your Honor today that would lead this witness to not be excluded, but just allow the full scope of her testimony to be presented to the jury. So Ms. Lane, Your Honor, is a former supervisor of the Drug Enforcement Administration. During the course of her work for the DEA, she came to investigate opioid diversion in the state of Florida. Her work involved work to pain clinics, to prescribers, pharmacies, including Walgreens, including CVS. So she had a wide purview, Your Honor, of a lot of information that would be relevant to this case and relevant to the jury. As a former federal employee, her testimony is governed by what are called TUI regulations. They don't come up that often in state court, Your Honor, but they're based upon a Supreme Court case by the name TUI v. Reagan, which provides that federal agencies can restrict the scope of testimony or depositions, live or deposition, that an employee can offer as to information learned during the course of their official duties. And to permit such a witness to testify, first, the party seeking the testimony has to submit what's called a TUI request, which the plaintiff did in this case. And the timeline on this is important, Judge. I'm just going to walk you through it briefly. We discovered that as far back as January 27th is the date on which the plaintiff made his first TUI request to the DEA for Ms. Lane's testimony. Walgreens was unaware of that at the time. Then, the plaintiff listed Ms. Lane on its February 25th witness disclosure along with over 130 witnesses, including several other DEA current or former employees, all as potential may-call witnesses. So there was no indication that they had submitted a TUI request for her specific testimony, though obviously for almost a month they knew they intended to try to call her as a witness in this case because they submitted a TUI request. On March the 30th, and this is the last exhibit to our filing, Judge, the plaintiff received a TUI authorization from the Department of Justice as to Ms. Lane's testimony. And then the next day, they disclosed to us Miss Lane as a witness they intended to be a will call witness they would call live at trial. As soon as they made that disclosure, we asked the plaintiff to provide us with this TUI correspondence, which is the last exhibit to our filing today, Judge. That didn't happen until April the 6th. We made several requests over the series of the time between March 31st and April the 6th. Email correspondence, those are the other exhibits to our filing, Judge. And the plaintiff essentially gave us a whole host of excuses for why they haven't provided the TUI authorization yet, ultimately did on April the 6th, late in the evening. And the reason this is so relevant, Judge, is because as you can see on the bottom of page 2 to the top of page 3 of the last exhibit, which is the TUI correspondence from the DOJ, the topics of Ms. Lane's permissible testimony are incredibly narrow. And they would present the jury with an artificially narrow version of the relevant facts. Facts that are very, in plaintiff's view, helpful to its case, while absolutely prohibiting Walgreens from questioning this witness on other relevant testimony that she could offer. Testimony that would be directly relevant to the comparative fault analysis in this case that the jury has to do, relevant to the Fabre offenses. Because as I indicated, Ms. Lane investigated a host of entities in Florida, all which were discussed by both plaintiff and Walgreens today during opening statements, and all of which would be relevant to the jury. But as you can see from the numbers, Judge, on the bottom of page 2 and the top of page 3, the numbered areas of permission, Ms. Lane's testimony is limited to only about Walgreens, the order to show cause, an investigation of the distribution center in Jupiter, Florida in 2012, the investigation of certain Walgreens pharmacies, again related to this order to show cause in 2012, and if you look down to topic 4, Your Honor, permissible testimony about her investigations and discussions with Walgreens employees. Another relevant fact, Judge, when you think the explanation for why it took from March 30th to April 6th for the plaintiff to get us this TUI correspondence is there's also 2 pieces of permissible testimony that involve CVS, and their opposition brief indicated that the reason they delayed sending us the TUI correspondence was because they were still in discussion with the DOJ as to whether the DOJ, since CVS had settled, was going to withdraw or issue a new letter that did not even include those CVS components. So the plaintiff was seeking, after receiving the TUI correspondence, which it indicates they received by email on March 30th, they wanted to further restrict the scope of Ms. Lane's testimony by removing even the CVS components of it. And Judge, there's no Florida law that supports the court or the plaintiff to come in and put on a witness that can talk about only a minute set of relevant facts to the jury, and the jury is then barred from hearing anything else relevant to the case, relevant to the claims, relevant to the defendant's defenses that witness can offer. And there is, as we would say, Your Honor, a solution to this problem, and it is simply, instead of calling Ms. Lane tomorrow or this week, would be to give us time, Walgreens, to submit our own TUI request to the DOJ that allows us to question this witness on the full scope of her knowledge. That can be done. There was no reason they had to structure this and disclose it to us on the eve of trial. They were going to call this witness as early as Tuesday after delaying and handing over the TUI correspondence in the first place. And their principal rebuttal for this, Judge, they have no case in the state of Florida that supports, the logic they want to ask this court to endorse, which is we can limit this witness to a minute portion of her relevant knowledge and only present the jury with that and keep from the jury the other relevant information, is to say, well, under the Florida statutes, cross-examination is limited anyway to the scope of what we ask this witness at trial. Now, obviously, that's Florida statutes generally say that, Judge, but again, here, the plaintiff is taking an artificially narrow view of what relevant to the direct examination is. And there's a Florida second DCA case. This is the Pedro v. Baber case from 2012. It's 83 7 3rd 912. I'm going to read it, the court, into the record from Pin Site 917 of that opinion, which is talking about the exact statute and the scope of it that the plaintiff cites in her opposition. Cross-examination should always be allowed relative to the details of an event or transaction, a portion only of which has been testified to on direct examination. As has been stated, cross-examination is not confined to the identical details testified to in chief, but extends to its entire subject matter and to all matters that may modify, supplement, contradict, rebut, or make clear the facts testified to in chief. Your Honor, that's exactly the situation that we are dealing with here. We have a plaintiff who wants to present a witness that they want to bring in with the imprimatur of the DEA to talk about investigations only of Walgreens and prohibit Walgreens from asking this witness about all her other investigatory work directly related to pain clinics, other pharmacies, prescribers of opioids, all entities and individuals relevant to the comparative fault analysis and relevant to our Fabry defense. Allowing a delay in the presentation of this witness, Judge, so that we can make the TUI request will eliminate any prejudice the plaintiff can put on this witness, and Walgreens will be able to conduct a full cross-examination. So we would ask, Judge, if the plaintiff is insisting on calling this witness this week, the testimony be excluded on this basis. It's not compliant with governing Florida law. It's not compliant with the second DCA law. And the alternative, give us the time to make our own TUI request, which we do immediately, so we can have the full scope of this witness's testimony.
All right.
Thank you.
Response?
Thank you, Your Honor. Tom Schultz, on behalf of the plaintiff, no relation to Alex Schultz that I know of. The motion should be denied. I want to give a bit more of an exegesis than I normally would because Your Honor has not had the time to read the briefs. There's a bit of background. As Mr. Schultz said, Ms. Lane is a former DEA investigator who will testify this week about her role in the DEA's investigation of the Florida Walgreens pharmacies that we talked about this morning. Because she is a former federal government employee, we are required to seek authorization from the Department of Justice for her testimony, and we're required to specify the topics of the testimony that we're actually seeking to have her testify about. We did that in January this year, and on March 30th, DOJ authorized her to talk about the DEA's investigation into Walgreens. That is a pretty standard practice in federal court and state court when it comes to testimony of former government employees. Now, Walgreens' entire motion is premised on an objection to the scope of the authorization that the government has given for Ms. Lane's testimony. I'm going to make 3 points on that. The first is that we did not set those limits on our testimony. Those are limits that the government, the Department of Justice, placed on Ms. Lane's testimony. It said that she can talk about the DEA's investigation of Walgreens, but not other investigations. So it's simply incorrect.
You requested that, right? They didn't just come up with that on their own.
Yeah, we requested that she talk about the DEA's investigation of Walgreens, but we did not say to the government, and don't let her talk about anything else. We just said, this is what we want her to testify about, and that's what TUI regulations say. You have to tell the government what you want the witness to talk about, and we said, this is what we're interested in. So it's just not true that we somehow engineered the limited scope of testimony. That's the government's decision, it's not our decision. Point 2 is that all the questions that Walgreens wants to ask Ms. Lane about are impermissible anyway under Florida law, because they are outside the scope of the testimony that she will offer on direct regarding the DEA's investigations into Walgreens. They want to ask her about unidentified and unrelated investigations that she did about into pill mills or whatever else they want. They haven't really told us. Those are not related to the DEA's investigations into Walgreens that we're going to talk about with her on direct. And Florida Statute 9612 expressly states that unless the court grants an exception in its discretion, cross-examination must be limited to the topics of direct examination. So the Walgreens' complaint is not with the TUI regulations or the authorization, but with Florida law and the Florida Evidence Code. Point 3 on this issue is that there's simply no unfairness here. Walgreens is going to put in, apparently, a lot of evidence in this case about other causes of the opioid crisis, other investigations, and they can do that in their case in chief. They're not limited to just cross-examining Ms. Lane about other issues. They can do that with other witnesses, their own witnesses. So it's not like this is a clamping down on Walgreens' defenses. This is one witness that they could not cross-examine anyway about these issues about because they're outside the scope of testimony. And it's just not going to affect their case that much. The last point I want to address here, before I get to their proposed solution, is the insinuation that this is somehow cloak and daggers, that we delay disclosing Ms. Lane as a witness. That is also not true. I just want to give a brief timeline on Mr. Schultz. Mr. A. Schultz did that before. I just want to kind of clarify a few things. We submitted the TUI request, as Mr. Schultz said, on January 27th. February 25th, a month later, was the deadline for disclosing witness lists. We disclosed Ms. Lane on that date as a may-call witness, even though we had not received authorization for testimony at that point. We then did receive authorization for testimony from the government about a month later, on March 30th. One day later, we amended our witness list to change Ms. Lane from a may-call witness to a will-call witness. Then, a few days after that, on April 4th and April 6th, we had a conversation with the government about, first to clarify the scope of a few of the topics, just to make sure that the questions we wanted to ask were within the scope of what the government was interpreting the scope to be. And also to make sure the government didn't want to reauthorize a TUI letter in light of the recent CVS settlement that happened around that time. We got confirmation on April 6th that the government treated the March 30th TUI letter as final. And a few hours later, that same day, we disclosed the final TUI letter to Walgreens. So we have been diligent throughout this process in disclosing Ms. Lane as a witness and a TUI authorization. Now, to Walgreens' proposed solution. If Walgreens wanted to have Ms. Lane talk about these topics, they could have disclosed her as a witness on its own list, as an affirmative witness, and could have sought TUI authorization for her long ago. They have known since 2012 that Ms. Lane is a relevant witness to this case because she was slated to testify against Walgreens in the DEA's investigation back in 2012. And they've known at the latest since February 25th, 6 or more weeks ago, that she was a potential trial witness for a plaintiff in this case because we disclosed her on our witness list at that time. They could have sought TUI authorization at that point if they had wanted to seek testimony from Ms. Lane on unrelated investigations besides Walgreens investigations. They did not do that. They're asking to do that now. They can certainly do that now. They can seek TUI authorization now and then bring back Ms. Lane in their own case and ask her more about other investigations. But to delay Ms. Lane's testimony at this point until Walgreens has had a chance to do that will effectively mean that she cannot testify in our case. It takes weeks or months to obtain TUI authorization to get a witness to testify, and it's just not going to happen in the next few weeks in time for her to testify. And certainly not this week when she's testifying in this case. She's already down here, she's ready to go. So it would really disrupt the case and probably mean that she's not going to be able to testify at all for us. So for that reason, and for the reason that there's no unfairness here for her testifying, we would ask the court to deny the motion. Thank you.
All right, brief reply.
Very brief. Thank you, Judge. Your Honor, thank you, and like all lawyers, I promise to be brief. The issue is this, Your Honor. We still do not have, the court does not have, plaintiff has not produced the January 27th affidavit referenced in this TUI letter. So we don't know what the scope of what the plaintiff asked for. They make it seem as though the DOJ decides what her testimony is and just sends something back. They make the request. They are hand-picking, Judge, what they want this witness to testify to and refusing to produce the relevant underlying affidavit subject to that. And Judge, it's not like we weren't interested in those types of correspondence. Request for production number 29 in our RFPs asked them to produce all documents constituting or referring or relating to communications between you and the DEA relating to Walgreens. They waited until after the close of discovery, then they submitted something that would clearly respond to this RFP, seeking an unduly narrow scope of testimony, and Mr. Schultz, his argument, again, Your Honor, said, well, we wouldn't be able to call her. That's what Florida law requires. He talked exactly what I said. The second DCA, and that opinion I read, disagrees with Mr. Schultz on his interpretation of the scope of cross-examination. Your Honor would not allow a sheriff's deputy to come in to testify to a jury in a car accident case that he witnessed the defendant's car hit the plaintiff's car, but then keep from the jury and prohibit the defendant from introducing evidence that a second car had hit the defense car and pushed into the intersection, causing the accident. That is a parallel to what we have here, Judge. We have evidence clearly relevant, again, mentioned in Mr. Webster's opening, mentioned in Mr. Derringer's opening, pill mills, other pharmacies. These are Fabry defendants in a comparative fault case. They cannot cherry pick evidence and restrict us from having this testimony. We spoke to the AUSA's office. They were prepared to receive our jury request. We believe it is very possible this witness could testify properly under the full scope of Florida law.
Thank you.
Thank you.
I'm going to deny the motion. I think there's, the plaintiff gets to choose what the scope is that they want to call her for, and that's, by Florida law, you're limited on the scope for cross-examination. I think that's something that's going to prohibit testimony regarding subjects that are outside the jury request anyway. So I'll deny the motion. Anything else we need to take care of today?
Let me first state, Your Honor.
All right, if you could, the clerk has some questions about evidence, if you could just stay after and talk to her.